I have your lordships kind leave to mention a matter. My lord, your lordships had fixed this matter today, my lord, but somehow, my lord, it's not appearing in the list.
Tomorrow.
One thing, my lord, Mr. Mukherjee is leading me. He's in some difficulty in the next 2 weeks. Any day in the first 10 days of August, he said he'll come and do the matter, my lord.
Mr. S.N. Mukherjee?
Yes, my lord.
Let it be listed tomorrow and then we'll fix
Very
it.
well, my lord. Great.
My lord, kind leave, my lord, to mention a matter for leave, my lord, to file an appeal without the certified copy of
Order.
My lord, order dated is 11th of my lord December 2014, read with 16th of December 2014. I come to know, I am my lord not a party in the my lord proceeding, the main proceeding. I came to know of the order only my lord in 2025. I am also filing an application for condonation of delay, explaining the grounds, my lord. I am grateful, my lord.
Your Lordship, I am appearing on behalf of the appellant. I am led by Mr. Gunjan Shah in this matter. I am praying for a 15 minutes short Passover. Your Lordship, he is stuck in the rain due to heavy rain.
Passover.
Achha.
May it please. রাখো, অবশ্য clear করো। রাখো, খুলে রাখো, খুলে ছেড়ে দাও। বই আনো, বইগুলো আনো। দিয়ে যেগুলো রাখবে রাখো। My lord, I have already placed the judgment under appeal. Now I challenge the judgment and appeal under appeal on the ground that the plaintiff has failed to prove the case pleaded. Though in the written statement of the defendant number 1, there is a pleading to the effect that the plaintiff has not.
What is that surveyor's report was not brought on record by.
These are there now. Well, the defendant number 1, the appellant has said that plaintiff has committed breach of contract. But since the defendant number 1 did not adduce any evidence, I have not, my lord, ventured to support that pleading without any evidence. The entire submission before your lordship on the last occasion was to show that the plaintiff has failed to prove the case pleaded. Now, to that, my lord, I shall rely on several judgments, but just for short recapitulation, there are 2 limbs of the claim of the plaintiff. 2 trucks lost, 1 truck accident. So far as the surveyor's report, absence of surveyor's report in evidence is concerned, that relates to the second limb. Because if you can't, you'll have to prove that the third truck met with an accident and it has suffered this much loss. Without the surveyor's report as evidence, plaintiff could not have proved the amount claimed in respect of that particular truck. So far as the first 2 trucks are concerned, lost case, those are dependent on, I think, Annexure J, the letter from the transporter to the plaintiff. And mere production of the letter received from the transporter would not prove the truth of the contents of that letter. Broadly, these are my respectful submission in respect of 2 claims. In addition to that, there is the question of limitation. When someone claims the exemption of the period under section 14, I shall place that, you will have to show that the proceeding which was followed up by the plaintiff in a wrong forum earlier started on date X and ended on date Y. And they must claim exemption for that in respect of that pendency of proceeding. Now, if I first take up the point of limitation
This you had said that the order of NCDRC has not been
Yes.
tendered.
Paragraph, Milord, kindly have a look at paragraph 15 of the plaint at page 9 of the paper book 1, and I shall go to the section. This is paragraph 15. They say between the period July 2006 to March 2008, the plaintiff has pursued the remedy under the Consumer Protection Act 1985, and ultimately by an order dated 31st March 2008, the National Consumer Dispute Redressal Forum has held that the plaintiff will be entitled to obtain benefits under Article 14 of the Limitation Act in the event it files a suit. Kindly come to section
Mr.
14.
Ghosh, may I ask an academic question?
My lord.
Nothing to do with this case, really. Assuming NCDRC passed an order holding that the present plaintiff is entitled to Section 14 benefit, is that binding on this court?
No. Miller, that is precisely the second limb of my submission in case of limited. He can only observe. The decision is to be taken by the court in which the suit is filed.
That is what I understand is the law.
I'm grateful to you. I don't have to repeat that part, Miller, in my submission. You prove your case. I initiated the process. This is the pleading. Pleading is not proof. And it is needless to say, my lord, in order 7 of CPC, if the plaintiff wants any exemption from the limitation period, he has to plead that particularly. That is paragraph 15 here. But that is not proof by itself. And my second submission would have been this, that the forum in which the plaintiff proceeded wrongfully cannot decide that the period of pendency of that proceeding should be the period of exemption under Section 14 of the Limitation Act. Now, so far as Section 14 is concerned, if your Lordship of the Limitation Act, your Lordship kindly have a look at the provision. In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or appeal or revision, against the defendant shall be excluded, where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court which from from defect of jurisdiction or other cause of like nature is unable to entertain it. Now, in computing the period of limitation for any application, etc., kindly come to explanation part. A. For the purpose of this section, A, in excluding the time during which a formal civil proceeding was pending, the day on which that proceeding was instituted and the day on which it ended shall both be counted. This is very important because the deciding court, the court in which the subsequent suit will be filed, the court will have to decide on the basis of the material on record, the evidence on record. And at the risk of repetition, that can be proved only by under section 76, where court will take into consideration the original records of that court need not be produced. The certified copy will suffice. So, in absence of that, in my most respectful submission, this honorable court,
and also the court will have to see why that other forum did not entertain.
My lord.
To get benefit of section 14, the reason must be, or the ground for not entertaining must be defect of jurisdiction or like cause. So one has to look at the order to find out.
I'm really, my lord, that would have been my third submission. Your lordship kindly recall in a brief spell of matter, a spell of time, particularly I do not name the honorable judges, but I mention here the honorable Justice Ajaynath Ray. What we usually do, we used to file the winding up application. And at the time of filing the winding up application, a self-injunction was obtained.
To stop limitation.
To stop limitation. Why? Because before Justice Ajaynath Ray, we had to withdraw one winding up application because it was not heard within 2.5 years, for whatever reason. Then I advised my client to file a suit in Shialda court, and after obtaining the leave from the court. Because these are, I should say, like V. You can file winding up petition, you can file regular suit. It is your choice. For example, execution. If I have a money degree, now for the money degree, 12-year limitation execution, and if I move an application for winding up for 34 years, I took the point that it is barred by limitation since you have moved the application beyond the period of 3 years before the company court. So court has to see, the court means the court which is deciding the second suit have to see what was there in the order. So I say simply firstly, that is the first thing we do to satisfy the court to have the exemption under section 14. Because it is only paragraph 15 which deals with the exemption and nothing else. And to that, my written statement says in paragraph 16 possibly, save as will appear from records. In the context, kindly take it as the records of that earlier proceeding. And section 3, needless to say, section 3 of Limitation Act.
Yes.
It has to be dismissed if it is not filed within limitation. So that takes care of the issue of limitation here. Now comes the failure of the plaintiff to prove the case pleaded in the plaint. All the judgments which were relied on by the plaintiff before the Honorable First Court relates to the obligation of the defendant, insurance company, to prove the breach, if any, committed by the insured. And I shall point out from those judgments that in those cases, the proof of the claim or proof of the, so to say, accident was not in dispute. So, in that context, the Honorable Supreme Court of India, Honorable Delhi High Court, was pleased to lay down the law. Lord, a decision is an authority for what it decides. And not what can be deduced therefrom. I think there are many just famous line of Justice Satyabhrata Sinha, at least, and many other honorable judges. First thing I was 1901 King's Bench, a single.
This was first Privy Council's observations in some case.
Yeah, 1901.
Possible.
Now let us see whether the plaintiff has been able to prove the case pleaded in the plaint. First law, judgment will I address your lordship on the topic that the proof that the truth of the contents of the documents tendered, particularly Exhibit J, the letter from the transporter, has not been proved by the plaintiff. Exhibit J to
Exhibit J.
হাতে লেখা চিঠিটা কত?
Exhibit J is the transporter's letter.
Yes. Page bolo. Letter bolo. Quick.
Yes.
And of course,
39.
our 72 full bar.
So,
Third paragraph of that letter speaks about FIR in Burdwan police station. Now, this is a letter written by the transporter to the plaintiff. Page 139.
Yes.
My lord, in short, my submission is, if I receive a letter from X, I can always come to court and tell the depose before the court that I received this letter, which was sent to me in usual course, etc. I know his signature. I am acquainted with his handwriting in the letter. The letter goes, as marked as exhibit. But unless I accept, unless I personally know the contents of truth of the contents of the letter, that person has to be brought. Because the elementary Miller proposition is section 60 of the Evidence Act. Kindly have a look at
Normally, the author has to prove.
author. Now kindly take for judgment reported in 1972, 4 Supreme Court cases 562.
707
By যেটা দিচ্ছি যাও না
72 4
ওই তাকিয়ে দিলাম তো
72 4 এটাই ছিল, আমরা প্রিন্ট আপনার হাতে প্রিন্ট নিয়েছি 707
এই প্রথম কেস এটা কি করে হবে
ডিকশন অফ
দেখো সাজিয়ে রাখো তুমি কি করছো বলো
Can you take this? We'll be relying upon that also, but subsequent. Can take this.
হ্যাঁ বলছো প্যারাগ্রাফ 15 পার্টিকুলার
ভুল কেস দিয়েছে আগে।
আচ্ছা একটা দিয়ে দিই।
হ্যাঁ নিয়ে নিন।
Paragraph
15. The plaintiffs wanted to rely on Exhibit A12 and A13, the day book and the ledger respectively. Your Lordship has got it, paragraph 15. The plaintiff wanted to rely on Exhibit A12 and A13, the day book and the ledger respectively. The plaintiff did not prove these books. There is no reference to these books in the judgment. The mere marking of an exhibit does not dispense with the proof of the document. It is commonplace to say that the negative cannot be proved. The proof of the plaintiff's books of account became important because the plaintiff's accounts were impeached and falsified by defendant's case of larger payment than those admitted by the plaintiff. The irresistible inference arises that the plaintiff's book would not have supported the plaintiff. What I am on, this will apply to both the handwritten letter of the transporter and the surveyor report. For the surveyor report, it is 1 degree more because that has not been put in evidence as exhibit. Next judgment, 2010, 4 Supreme Court cases, 491, paragraph 25. After discussing the evidence in that case, the Honorable Supreme Court has observed in paragraph 25, we are of the firm opinion that mere admission of a document in evidence does not amount to its proof. In other words, mere marking of exhibit on a document does not dispense with its proof, which is to be done in accordance with law. And, my lord, paragraph 31. I'm not reading out the entire, my lord, judgment. Under the law of evidence also, it is necessary that contents of the documents are required to be proved either by primary or by secondary evidence. At the most, admission of documents may amount to admission of contents, but not its truth. Documents having not been produced and marked as required under the Evidence Act cannot be relied upon by the court. Contents of the document cannot be proved by merely filing in a court. Next, I rely on a single bench judgment of Bombay High Court, because there, my lord, how a document has to be proved has been clearly explained, relying on Supreme Court decision. I shall rely on the Supreme
Should
Court.
we retain this or return this? The first one that your junior handed up,
No, that will come later.
later.
company cases, 82 already.
How? It is the Supreme Court cases version, AI 1983 Bombay 1. And corresponding judgments are there. Kindly take pages 3 and 4. Section 63, your lordship has got, is not paragraph numbered. Section 63 in the third page, I believe.
Yes.
From the top.
Section 63 states that the secondary evidence include an oral account of the contents of the document given by some person who has seen it. That person does not give the evidence of the truth of the contents of the document merely by reason of having seen it, but of what he saw. This is more important. In section 63, therefore, the expression contents of a document must mean only what the document states. Section 61 provides that the contents of a document may be proved either by primary or by secondary evidence. The expression in section 61 must therefore also mean that the document states and not the truth of the document, what the document states. This is important. This is what I am trying to emphasize. Secondly, section 61 and 62 read together show that the contents of a document must primarily be proved by the production of the document itself for the inspection of the court. It is obvious that the truth of the contents of the document, even prima facie, cannot be proved by merely producing the document for the inspection of the court. What it states can be so established. Thirdly, it is laid down that the writer of a document must depose to the truth of the contents. 3 judgments must be noted. Then AI 1971 HC 1949, this is the corresponding judgment. I shall point out to your lordship. The contents of this letter were proved by the evidence of Ramchandra Sharma, who stated that he knew the handwriting of Swamiji, with whom he had had correspondence even early. His evidence thus was sufficient to prove that Swamiji wrote this letter to Ramchandra Sharma and that the statements contained in the letter were made by the Swamiji himself. It is true that in absence of Swamiji, the correctness of those statements cannot be held to be proved. Thus, the evidence of Ramchandra Sharma proved the contents of the letter, but not the correctness of those contents. So, Exhibit J. Milord, this is the judgment of the Honorable Justice Barucha, but I follow this judgment because it's a basic principle of Evidence Act, how to prove a document in court are explained here. Now, in this judgment, that particular judgment of Honorable Supreme Court is mentioned, AIR 1971 Supreme Court 1949. Let's kindly have a look at the corresponding SCC version. I have handed over to your lordship. 72 4 SCC 707. There, your lordship will find in paragraph 7. Fifth line possibly, it appears to us, your lordship has got it. It appears to us that the High Court was quite wrong in holding that the letter was not relevant. The contents of the letter were proved by so-and-so, who stated that his handwriting of Samiji, with whom he had correspondence even earlier, his evidence that was sufficient to prove. The same thing has been quoted. But if the truth of the content is not proved, it will have of no effect. It is relevant because it will show that the transporter wrote a letter to the plaintiff. It's a relevant fact, but not proved. That truth of the contents of that letter is proved. So these 4 judgments take care of Exhibit J to show that the truth of the contents of the said letter has not been proved. The letter of the transporter.
Yes.
Now the entire claim of the plaintiff on account of the 2 lost trucks is dependent on this particular document, Exhibit J. Whether or not it was plaintiff's duty to file FIR, it was the plaintiff's prerogative under the insurance clause to take steps. Those are not factors here because I cannot prove without producing any evidence before the Honorable First Court that the plaintiff has committed breach of the contract. My case is whether the plaintiff has been able to prove the case pleaded. This is Exhibit J. So far as the surveyor's report is concerned, I have placed from the judgment under appeal that the Honorable Judge has relied on portion of the that particular document. There, my humble submission is in one of these judgments, it is mentioned that if you tender the document and marked as exhibit, that by itself will not prove the truth of the contents. And here, admittedly, the surveyor was not called as witness by the plaintiff.
Plaintiff asked for a copy from the defendant. Write a copy. What is the truth? And the service report is exhibit,
Service report of
was not tendered in evidence at all. Surveyor's report,
survey, no,
not tendered at
no,
all.
that chart I have shown.
Oh, yes, yes. The chart in the judgment.
So in other cases, there is confusion when we learn when it is to be found out from a judge's brief of document. Before some honorable judges, the practice followed. I also suggested that please keep a separate exhibit file, even if that is in the judge's brief. It will be easier for the honorable judge to find out 35 exhibits out of 7 volumes of judge's brief of document. It happened in one case, 14 volumes. How could I expect the honorable judge to look? Because it becomes very difficult to make submission in court also. Kindly look at volume 13, go back to volume 2. So a separate compilation of the exhibits, just like paper book was prepared and matter was argued. Here, fortunately, the chart does not contain the name of the surveyor's report. Another thing, it is very interesting. If your lordship kindly go through the print, a few paragraphs. Print, paragraph 9. Page 7, volume 1. Particular. Principal amount of first consignment, that is 3149, such and such. Then interest at the rate of 18% from the date of dispatch to 7/5/2008. This is interest is the compensation for delayed payment. Your lordship knows from section 73 of the Contract Act. Kindly have a look at Contract Act, Barbaros, section 73. When a contract has been broken, the party, your lordship has got it. Ache ene to. Section 71. When a contract has been broken, the party who suffers such breach, here the plaintiff, is entitled to receive from the party who has broken, here the defendant number 1, broken the contract, compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Such compensation is not to be given for any remote or indirect loss or damage sustained by reason of such breach. Next 2 paragraphs, I am not, kindly see illustration N. We talk about compensation. What is that? Illustration N for Nagpur. A contracts to pay a sum of money to B on a day specified. A does not pay the money on that day. B, in consequence of not receiving the money on that day, is unable to pay his debts and is totally ruined. A is not liable to make good to B anything except the principal sum he contracted to pay, together with interest up to the date of payment.
This is because his ruination is too remote.
And I look at this, these are nothing but, this illustration are nothing but old
Correct.
English cases,
Correct.
in short. Kindly look at this from this angle.
I don't think in England law of contract has
Okay.
still been codified. It is still common law,
Yes.
judgment law.
And that is why I think Justice Macaulay, Lord Macaulay, when to give guidance to the Indian lawyer, embodied the illustrations, which are very helpful, because all of us know but that a compensation is to be paid. All of us know that that compensation should not be removed. But what should be the compensation of delayed payment, particularly in case of hire purchase agreement? So only the interest for delayed payment. Now from this I take the clue. It is interest from delayed payment. Amount is to be paid when? When it is due. And since when they have claimed here in paragraph 9, 28 September 2003, date of dispatch. That your lordship will find in paragraph 5. Two dates are there, last but one line in paragraph 5, 28 September 2003, 10th October 2003, dates of dispatch of the two consignments. Yes. And that has been specified in paragraph 9, I and II.
Yes.
So on the day that it was opened, money did not become due and payable under the insurance policy. One has to prove, in addition to pleading, that it was lost. Then kindly come to Roman 3. Date of dispatch, that is 12 October 2003. That your lordship will find in the continuation of paragraph 7 at page 7. I think it is 4th line from the top. And the interest has been allowed as claim from the. Now this claim itself shows the malafide nature of the claim. Why I say so? You have just said, pleaded, that the two trucks are lost. You have produced a letter from and for the plaintiff, that's the end of the matter. That is not the proof. That the proof of the fact that the trucks were lost. That's what I'm on. Kindly imagine an undefended suit. In undefended suit, court can pass a judgment on the basis, under Order 8 Rule 5, that no written statement has been filed. But the court has the discretion under Order 8 Rule 5 sub Rule 2 to ask the plaintiff to prove his case. Now, if the court has given such a direction, passed such an order, then plaintiff cannot say, I won't follow the rules of the game. That means rules of the Evidence Act. Precisely that is my respectful submission. I am not there. Kindly imagine a situation. Plaintiff has not proved that trucks were lost. Plaintiff has not proved what they are entitled to claim. And particularly interest for claim of interest shows that the claim was not genuine. Money was not payable under the insurance policy from the date it was dispatched. If it was lost, then that is a different thing. Now, let us look at the judgments relied on by the plaintiff in the first court. I shall try to distinguish them.
কোনটা আগে?
2017 SCC online, Delhi, 9511. Will kindly keep a note. These were the judgments relied on by the plaintiff.
Recorded in the judgment.
I shall try to be as brief as possible, only point out the factual aspect, what was the point involved there, and what was the decision. Kindly come to paragraph 2. The subject suit was filed by the respondent plaintiff, pleading that it had insured the appellant consignment of 1488 cartons of fruit juice weighing such and such kgs of value such and such, and which consignment was covered under the invoice number such and such dated 23rd March 2010. Then it was loaded. After 3 lines, the services of the defendant number 1 suit, the respondent number 2 herein were taken with respect to transportation. So there the transporter was defendant number 1 and the transportation covered by such and such. Then after 1 line, this vehicle met with an accident between Indore and Bhiwandi, resulting in consignment being delivered with 1082 cartons leaking and short supply of 137 cartons. With respect to a loss or damage, certificate was issued by the transporter respondent number 2 on 5th May 2010. Kindly note, a certificate was issued by the respondent number 2. That is the transporter. Here is transporter has not come forward. No. The surveyor of the appellant also reported loss of rupees 7 lakhs and odd, but the appellant has rejected the claim in as much as the weight of the consignment was 19497, but the permissible limit of carrying capacity of the vehicle in terms of the registration certificate was only 183367 kg. So, beaches of the insured. That was the point in law. And after discussing the fact and the law, particularly in paragraph 4, the 5th line, 2016 CSCC 100, your Lordship has got the judgment. I shall place it to distinguish. Paragraph 4, 5th line, 2016 300, and which held that the compensation under insurance could not be denied unless and until the clause which pleaded to be in breach of is a reason for happenings of the accident. This presupposes that the accident or the loss of truck is proved. Under that circumstances, if you kindly come to paragraph 16, it is argued by the learned counsel for the defendant that since there is a clear violation of the warranty description of the policy terms and the conditions, therefore the claim was not payable, which were duly informed to the insured with a letter dated such and such. In that, my lord, context, if you kindly come to paragraph 22. Applying these settled principles of law to the facts of the present case, I may observe that the defendant number 2 has failed to prove the fact that the accident occurred due to the overloading of vehicle or lorry. Therefore, in view of above-mentioned facts and circumstances, the rejection of plaintiff's claim by the defendant number 2 on the ground that there is breach of the terms and conditions of the policy, that is warranty number such and such, schedule number such and such, stating thereby that the vehicle or lorry was overloaded is illegal, wrong, and by no means absolves the defendant number 2 from its liability. So it is only in that context which I am not argued before your lordship.
All this is trial court's observation,
Yes.
not Delhi High Court's.
No, not the court. After evidences were adduced, the factum of loss is proved. I am grateful to your lordship. This is a point of law whose fault it was. The question, moot question was whose fault it was, whether the insured has committed breach of the contract. If so, the insurer is not liable to pay. That is not the issue or the point I have submitted before lordship. Next one, relied on by the plaintiff, 2016, 3 SCC 100. No. Paragraph 2 first. The brief facts of the case, which are required to appreciate the rival legal contention advanced by the learned counsel appearing on behalf of the parties, are stated in brief as hereunder. The appellant was the owner of a Tata Motors good vehicle bearing such and such registration number. The vehicle was insured with the respondent company by policy number such and such. Then after 2 lines, the said vehicle met with an accident on such and such date on account of rash and negligent driving of the offending vehicle, kindly note, bearing registration number such and such. In this regard, FIR number so and so dated such and such was registered with the jurisdictional police station Sadar, whatever, for the offence punishable under such and such. So, in that fact, it is recorded. Then 3. Appellant incurred expenses amounting to such and such for the repair of his vehicle and also informed the respondent company, etc. And after 3 lines, after inspecting the vehicle, the surveyor assessed the damage caused to the vehicle at 90,000, whereas appellant preferred a claim of rupees 1,64,000. No surveyor report is there in the present case on record as evidence. Then, in addition to the above, the respondent company appointed such and such claim manager, etc. That is in the facts of the case. Then paragraph 5. What was the point involved there? The respondent company filed a detailed written statement before the district forum disputing the claim of the appellant. It took the plea that the complainant had violated the terms and conditions of the policy as 5 passengers were traveling. Again, my lord, violation of terms and conditions. That was the point to be decided. Now, after discussing, my lord, several judgments, if you kindly come straight away to paragraph 16. I am not reading out the quoted judgments. Paragraph 16. My lord, page 107. It becomes very clear from a procedural of the above-mentioned case law of this court that the insurance company, in order to avoid liability, must not only establish the defense claimed in the proceeding concerned, but also establish the breach of the part of the owner insured of the vehicle, for which the burden of proof would rest on the insurance company. In the instant case, the respondent company has not produced any evidence on record to prove the accident occurred on account of overloading of passengers in the goods carrying vehicle. Then, after 3 lines, in the instant case, it is undisputed that the accident was in fact caused on account of rash and negligent driving of the offending vehicle by its driver, against whom a criminal case, FIR number such and such, was registered. So this is the distinguishing factor. This is authority, this citation is an authority for the proposition. If you have pleaded breach of contract by the plaintiff, you will have to prove it. That's all. Next one. 1985 to HCC 574. Paragraph 2. An accident occurred on such and such place, Margao, on such and such date, in which one Sita Gomes and her sister-in-law, so and so, were injured. Ida succumbed to her death injuries and Sita Gomes recovered. The offending vehicle was a pickup van belonging to such and such. In that factual context, kindly come to paragraph 6. The undisputed facts are the pickup van motor vehicle, being such and such number, belongs to the first appellant firm, and the second appellant is the partner of the firm. This vehicle was involved in an accident occurred in such and such. There is a concurrent finding that the vehicle was driven rashly and negligently by the partner who was driving the vehicle, and in this accident, Sita and Ida suffered injury. These are the factual findings there. Then paragraph 9, first line. Now, would the insurance company be discharged from the liability under the contract of insurance if, as contended by it at the relevant time, the appellant number 2 was driving the vehicle? Various issues were raised that has been discussed here. Then paragraph 10. A conspectus of these provisions shall show that where the pickup van belonging to the firm is being driven by a partner, it can be said that it is done with the permission of the owner, namely the firm, or with the implied authority. Then paragraph 12. If your lordship kindly come to 8th line from the top, sentence starting with the insurance company. The insurance company complains of breach of a terms of contract which would permit it to disown its liability under the contract of insurance. If a breach of a term of contract permits a party to the contract to not to perform the contract, the burden is squarely on the party who complains of breach to prove that the breach has been committed by the other party to the contract. The test in such a situation would be who would fail if no evidence is laid. I have not argued this point. Then, dear Lord, of course, the Supreme Court judgment. After that, Milord, 2 lines. Not an iota of evidence has been laid by the insurance company to show that the second appellant did not have a valid driving license to drive the vehicle. Your Lordship will have a glance. The question was put to that particular person in cross-examination, produce your driving license. He failed to do so. That is it. But the Supreme Court has said, no, there won't be any adverse inference under 114. You could have proved it. Paragraph 14, Your Lordship, kind. Mr. Sharma, fourth line of paragraph 14, did not dispute the second appellant had a driving license. His grievance is that, having failed to produce the same, when called upon to do so in cross-examination, an adverse inference be drawn against the same, and he did not have a valid license to drive the pickup van. The submission fails to carry conviction with her. The burden to prove that there was a breach of contract of insurance was squarely placed on the shoulders of the insurance company. Then the last line, the insurance company could have got the evidence produced to substantiate the allegation from RTA. If it goes, contrary to 114G, but third party insurance, Supreme Court was kind enough to allow. Again, at the risk of repetition, breach of terms of contract, I have not made any submission before Your Lordship. Next, 2004 CSCC 297. Your Lordship will find that it is mainly deals with, this particular decision mainly deals with the Motor Vehicles Act. Paragraph 1 at page 14 bottom. Interpretation of section 149 2AII vis-a-vis the proviso appended to subsection 4 and subsection 5 to the Motor Vehicles Act 1988 is involved in this batch of special relief petition filed by National Insurance Company, etc. Then paragraph 3. Suffice, however, is to point out that the vehicles insured with the petitioner were involved in accidents resulting in filing of claim application by the respective legal representatives of the deceased or the injured persons as the case may be. 4. Defenses raised by the petitioner company in the claim petition purported to be under such and such of the Act, Motor Vehicles Act were A. Driving license produced by the driver or the owner of the vehicle was a fake one. Driver did not have the license whatsoever. C. A license, although was granted to the driver concerned, but on the expiry thereof, the same had not been renewed. D, E, similar. In this context, after discussing various provisions of the law and judgments on that point, the Honorable Supreme Court of India has held at page paragraph 110 at page 341. Summary of findings. Kindly come to Roman 4, IV. IV and V, 5, Roman 4 and 5. Insurance company, however, with a view to avoid their liability, must not only establish the available defenses raised in the said proceedings, but must also establish breach on the part of the owner of the vehicle. The burden of proof whereof would be on them. In fact, the court cannot lay down any criteria as to how the said burden would be discharged, inasmuch as the same would depend upon the facts and circumstances of this case. So this is an authority for the proposition which I have not argued before. The breach of the provision of the insurance policy. Next one. In 2009, 5 SCC, 2009 5 SCC, 599. Very different. The kindly come to paragraph 3 of this judgment. The insurance company issued a comprehensive floriculture insurance policy for such and such period and charged premium of such and such. This was the factual aspect. Then, 7. On 28 November 1996, the insurance company informed the surveyor that the report included loss of polyhouses 7, 8, and 8, 7, 8A and 8B, whereas the policy covered only polyhouses 1 to 6. The surveyors were accordingly asked to reassess the loss on such and such date. Surveyors gave their clarification to the insurance company that all the polyhouses were covered under the policy of their asset. So this was the real crux of the dispute, whether 7, 8A and 8B were included, apart from 1 to 6. Now, in that context, it's mentioned in the judgment. Judgment 11. 5 judgments are mentioned. Kindly come to paragraph 15, the question. The question that arises for our consideration is whether comprehensive floriculture insurance policy issued by the insurance company to the insured covered polyhouses 7, 8A and 8B. 16. An insurance contract is a species of commercial transaction and must be construed like any other contract to its own terms and by itself. In a contract of insurance, there is requirement of abarima fide, that is good faith on the part of the insured, except this, in other respects, there is no difference between a contract of insurance or any other contract. Then essential of contract of insurance, kindly come straight away to paragraph 28. A careful consideration of the proposal form that sets out the particulars of the components which were to be covered and inventory of the property insured section 1 and 2 mentioned in the policy leaves no manner of doubt that what was insured was the existing polyhouses on the date of insurance policy. It is clear that the proposal and the policy, the two documents admit no ambiguity, and it is clear that 6 polyhouses covering area of such and such were covered by the policy. And in paragraph 30, conclusion of National Commission was affirmed. No error was found. Issue was whereas 6 polyhouses were covered by the the insurance policy, or 3 more. The last one is repetitive. Oh. Total 5 judgments they have relied on the aspect of breach of the insured, if any, of the terms and condition of insurance policy, which I have not argued here. I say I have not adduced any evidence to any witness. You know.
Yes.
Now, one respectful submission before your lordship, that we have made an application. I have not raised that before your lordship for additional evidence. But since the appeal is being heard, as a lawyer, I feel I should not trouble your lordship. But kindly take into account that also, that in view of that is, my lord, EA number.
Original it was 262 of
আপনি
20.
কত নম্বর বলো, লিস্ট থেকে বলো কত নম্বর?
GA2.
Yeah. Because in here, in short, we have stated that there are documents we have found out later after filing of this appeal, that which will prove that those trucks or tankers are still running on the basis of the RTO record.
Those particular, the trucks that went missing according to them.
But then, my lord, again, the question will come, again, as a lawyer, I see, even if your lordship allows that, one has to prove it. RTO document. RTI application made, বার করো document.
Application to the
বার করো।
The application টা করা হয়েছিল
এটা
এটা এই 102 কে একটু আসুন 102 টা শুরু হবে অ্যাক্টিভ বলে শো পেজ 102 আমরা অ্যাপ্লাই করে পেয়েছি আর কিভাবে পেয়েছি আমাদের লোক
Page 99, এই পেজ ওখানে পাবো তো?
হয়তো রানিং পেয়েছি
Page 99 of the insurance claim investigator wrote to the state public information officer regarding the information status. Now, if you kindly come to page 102,
পেয়েছি
it is 4816. কোনটা দেখো? Your lordship will find after vehicle particulars for internal use, right hand column WB23A 4816.
816 816
This is, if your lordship compares with the plain,
The second missing truck. No, we are not, but how does the document show that the truck is still running, flying?
active status after in the same column, engine number so and so, vehicle status, your lordship has got it. Right hand side.
Vehicle status,
After that number 4816,
yes,
fourth line from that particular number,
vehicle status active.
active, and this third column, registration valid up to 7 September 2005, fitness up to 7/7.
point of time ছিল তো ট্যাক্স দেওয়া ছিল এটা ছিল সেপ্টেম্বর 2003
This document is dated
Is dated C1
it was a document issued to us
2020 after the Barrackpur
ARTO
right hand column bottom, right hand corner,
yes 3/1/2020.
2020,
was issued from the record
after the judgment of.
he inquired in answer to an RTI application. This was issued and certified by we obtained it by RTO.
And another interesting aspect, after that vehicle status, your lordship will find comprehensive insurance in the middle.
Yes,
Comprehensive insurance after that valid up to, fitness up to. A sentence, comprehensive insurance from New Premier Insurance Company is valid from 11 September 2017 to 10 September 2018.
Documents are uploaded. That is why it is appearing in the official document. So it's not upload for it. You know the official.
Correct. Next one, your lordship will find
107.
at page 107. It is C149, that is the first one at the top. C149 is the number. Tata Motors Limited on the left hand column. Group carrier Then right hand column, RC status active. You lordship has got it. Right hand column. Then blacklist status on the left side. Blacklist status. Blacklisted by Salt Lake or ARTO. Then other source. Blacklisted means it was moving. Okay.
109.
একটা কত?
Sir, just a break number.
ও, আচ্ছা। প্রেয়ারটা বলতে
11.
kindly come to the prayers of the application at page
11.
11.
Yes.
Prayer A, an order allowing the appellant to rely upon the document and etc. And B, of course, that has become insured. They have filed affidavits. Complete. But I think we not on merit. If your lordship looks at the issue from the angle of proof of the plaintiff's case, there is a failure on the part of the plaintiff to prove its case.
That is all.
Grateful.
The intent and the written statement. To the extent I would first try to, because one of my learned friends' closing line was lack of by the plaintiff of the plaintiff's case. That is why I want to show your lordship, my lord, what is their case in the written statement. Was I required to prove something which factually has been accepted? Number one is the loss.
Mr. Sen, what Mr. Ghosh also said, please keep that in mind.
Yes.
Assume it was an undefended suit. Assume the defendant was not there.
Yes, I shall go on that.
Then, to what extent the
What I will,
plaintiff,
to get a claim under the insurance contract, what is the obligation of the plaintiff? But because kindly remember, this is an insurance contract, and if I may start with the insurance contract, it is in a negative form to say this, my lord. If your lordship just sees once, my lord, page 15, which is the contract. (15) is the first page regarding, my lord, the sum insured, what is insured. Then your lordship will see risk covered towards the bottom of the page, left hand side. All risk, including SRCC.
what is SRCC?
Oh, include strike, riot. The original insured, this is actually a typed copy. The original contract, my lord, was there in the trial court and at a plaintiff there the original contract mentioned it, my lord. Then, my lord,
Oh, it mentions here strike, civil commotion.
then, my lord, terms of insurance. Actually, my lord, the typed copy is not, there are some mistakes. Huh? But what I was trying to show your lordship is page 17, the risk covered. Achha. Well, actually, the main contract is given annexed as part of the judge's brief of documents, CE1, page 105. Kindly see what clause 1 at page 17. This insurance covers all risks of loss or damage to the subject matter insured, except as provided in clause 2, 3, and 4 below.
Page?
Page 17, there is a typed copy of Annexure A to the insurance contract. And same thing is there from 105 onwards. 105, 106 is the insurance document. Then 107, the policy starts. 107A is the typed copy. But I am relying upon these clauses of the insurance. It is covering all risk of loss and damage to the subject matter insured. My obligation is limited to showing valid insurance contract, risk of it is covered by the subject matter is covered by the insurance. Once I can show this, they have repudiated my policy, my claim on the basis of this insurance contract. They will have to show that my claim falls within the exclusion clause, that they cannot grant the claim under this insurance under clause 1 because it is subject to the exceptions.
How have you proved that the two concerned trucks went missing?
Yes.
According to Mr. Ghosh, the entire basis of that claim of yours, or the only evidence in support, is Annexure J, Exhibit J, the transporter's letter. But the author of the letter
has not been examined.
Did not come forward to prove the truth of the contents of that letter.
Your Lordship will kindly see what is the stand of the insurance company as regards the claim. Has the insurance company said that the ground of my claim is disbelief by them? Or is it the stand of the insurance company that that particular letter, my lord, that there was, I am guilty of willful misconduct and therefore claim is excluded under the policy? Now, my lord, that is why I want to show your Lordship kindly takes the written statement first. Written statement, my lord, starts from page 35. Kindly take, my lord, paragraph 6 at page 39, dealing with paragraph 5 of the plain. Is denied pursuant to orders received, plaintiffs dispatched such and such to Marico Industries or to any other party by 2 tankers of the defendant number 2 bearing number such and such. Further denied consignments were dispatched on such and such but could not ultimately be traced out and were lost. It is pertinent to mention here, kindly note that the complaint regarding alleged loss was lodged to the Burdwan police station after a time gap of 1.5 months of the incident with no plausible explanation for the delay in the inquisition. So, my lord, complaint was there. This is their case. A suspicion is raised regarding timing of the complaint. That I should have made a complaint earlier. I should have given a better explanation for delay in the complaint. So, this is not the same thing as saying that there was no complaint at all. Once a stand is taken on written statement that there is a delay in the complaint, to what extent, therefore, will the court require the proof of the original complaint by the person who has apparently made it?
So are you saying, Mr. Sen, that by making this statement in paragraph 6, they have admitted the truth
No,
of the contents of the complaint?
Existence of the complaint. There is a complaint which was made in respect of the loss of the truck. But unless.
So does that amount to admitting the loss? This is what I'm trying to understand.
That is what I was coming to. Suppose, Amrit Transport had come and said that this is the complaint which I have made. Even then, the contents of that, whether there was in fact a loss or not, will not be established. That is subject to investigation on the basis of the complaint. Final result of the investigation. Today, my lord, the insurance company cannot say that until and unless police unearths the truth of the contents of the complaint, I have no liability. That cannot be their case. Today, the case, what they have run is, there is some suspicion in the complaint because the complaint exists, but you see, you have filed it so late. There is some suspicion in the entire thing. But the submission which, subject to correction, my lord, the question which fell from your lordship, my lord, the actual fact of loss, this cannot be established even if Amrit Transport had come and proved that I have made a complaint. That stage is a later stage. An insurance claim will not depend upon what police says on the basis of that complaint. It is, I have acted as a reasonable, prudent insured, and I will have to show that the subject matter of my claim is covered by the insurance policy. You will have to prove, no, I have repudiated the policy on valid and genuine grounds covered by the exclusion clauses of the policy. This claim of yours is excluded from the policy because of these reasons. Lord, I do not have anything, it's not a greater responsibility. It is a case of my simple case is, you have repudiated my claim, and justification for repudiation is on you. Then, my lord, kindly see continuation of this line. The carrier's issuance of non-delivery non-delivery certificate to the plaintiff was after expiry of the limitation period, and prospect of recovery, even if any, against the carrier stood prejudice due to deliberate inaction of the plaintiff. So what is their case? It is a violation of my duty as an insured. They do not go into the extent that absolute frivolous complaint, suspicious to the core. That is not their case. Case is trying to raise some doubt on my conduct and to make it believe as if it could not have happened. They do not say, my lord, that it never happened. Complaint. It is not even a case that no complaint was there. Kindly see, it's a violation of duty of the assured. And what is my violation of duty? My violation of duty is this presupposes that there might be loss. If there was a loss, as a prudent, reasonable assured, you should have taken ABC steps which you have not done. So that is the premise of their defense. Due to deliberate inaction of the plaintiff herein, which is a distinct violation of duty of the assured as provided in the requisite clause mentioned in the policy. So they are going by the policy clauses and saying that I have breached the policy condition. Further, plaintiff did not initiate any legal action in time against the carrier despite there being misappropriation. Kindly see, my lord, misappropriation and loss.
Again, they are trying to justify why they will not pay your claim. See the last sentence. Is that an admission?
The said carrier lodged a complaint to Surveyor police station for missing of the vehicle carrying other consignment from Bajbaj to Nepal. Yes, they have said that there is for some other consignment, there is a complaint. But kindly see, the previous page also. There is no statement that no complaint was lodged. And complaint is lodged with delay, which results in violation of my duty. I have breach of my duty as an insured. Read with the other sentence of the same paragraph. I will, on the basis of this statement, I will show the other documents. But what I say, is the principal defense is to say that there is a violation of duty. But as an insured, again, as an insurer, it is not for the insurer, but subject to correction, I say that,
Yes.
the insurer cannot take, unless there is cogent material to say that the happening of the events behind the loss never occurred. That is not even their case in the contemporary correspondence. That is a case they can take subject to definite materials with them. Then there is no question of survey also. If the insurer takes a stand that the entire event never occurred at all, then the question of survey does not arise. Because you are saying that entire cause is a misnomer.
No, survey is only in respect of the vehicle which met with an accident.
Yes.
There can't be survey of a missing vehicle.
But the question is, here the correspondence should have stopped at the only on that in their stand that we have definite material to show that the loss never occurred. But here, that case has not been made. The case which my learned friend is trying to say, that also showing a police report does not help, because it does not establish loss. It cannot establish loss. Even if defendant number 2 has come and produced that police report, it will not, the same argument can be raised, that he is only proving the fact that he had filed a complaint. But it will not prove the factum of or the contents of that complaint that there was a loss. That is dependent upon a subsequent another factor, with which, in my respectful submission, the insurance company cannot be considered. So, my first point is, insofar as the now, let me come to the other. Insofar as the loss of truck is concerned, it is sufficient for the insured to show that he has taken a reasonable step as expected on the basis of the occurrence of that event. of loss. It is not required for him to prove the factum of loss before making a claim. Because then I will never be able to make the claim. Having regard to if it is the stand that the investigation must reveal, and then you can make the claim. That is probably.
And also, how will the insured prove the loss? The truck disappears, vanishes. If at all the insurance company can track it down and say.
That is what I am saying. Well, they have to specific with definite materials. They will have to tell the insured that, look here, your claim is based absolutely false because we have found that the truck is existing.
Which is what they are trying to say now, referring to those RTI replies.
No, that also I will have make myself.
Of course, you'll have to.
RTI is a statutory right available to them all throughout. The subsistence of the claim, during the pendency of the suit. So it is again, it is not you can exercise your right for the first time in the appeal and say that this is a document. You will have to explain that. Order 41, Rule 27, that's a complete bar until and unless you explain the court.
Correct.
On your insistence, just it is absolutely. I know, your lordship got very curious that how come the truck is still
active status.
Is an active status.
Insurance valid.
Then, we will have to. Then my next argument would have been, Order 41, Rule 27 is a very special procedure. We are going through the process of evidence during the suit, and when it coming in appeal, we are departing from the entire procedure and the court is taking into record one particular document without going into that exhibit and everything. Now the question is, what kind of documents the court would be ready to dispense with all kinds of procedural formalities with regard to taking on record a document which they had exercised at the suit stage. At the most, your document, my document.
Inter partes.
But an absolute third-party document obtained in the exercise of a statute, that to kindly remember, it is not coming in the usual course of correspondence. It is a statutory right you are exercising. Many a times your lordship has found discrepancies in Information Act documents also. So therefore, overlooking everything.
And there is no presumption of authenticity or
document which has been an information which has come under the Right to Information Act. Suppose, this document was there before the suit court. If I now take my learned friend's objections, he could not have exhibited it except by issuing a subpoena to them for production of the current insurance document. This is only an updated status downloaded from their computer. This is not the primary document of or a secondary document of insurance certificate to show it is status.
But current insurance document will not be with RTO.
RTO may have a fitness document, other documents on the basis of which they have granted permission. Today, my lord, if a new car is purchased.
Anyway, I'm sorry, I'm asking too many questions. You please proceed in your.
This I would have answered because Order 41, Rule 27, I would have argued that there must be some fetter on introduction of complete third-party documents. It is a special provision. Undoubtedly, it is a special provision, and that two documents can come in if I can satisfy the stringent requirement of the first part of Order 41, Rule 20, when I can invoke Order 41, Rule 27. So, if the provision is so stringent as to when I can invoke it, then the court must also ponder, my lord, whether it brings within its scope any and every document not belonging to either of the parties. Because it is a very special provision, court is not required to go into the trial for the purpose of admitting that document. So my lord, these aspects I will go into. For the time being, let me concentrate on the fact that paragraph 6, the only case of the defendant is I have committed breach of my duty in not making a complaint within a proper time, not insisting on non-delivery certificate within the stipulated time.
Not taking legal action against the transporter.
Yes. These are violation of duty of the insured
Under the policy.
according to them. So therefore, that objection they cannot take, that the defendant number 2 has not come, therefore contents of the police complaint is not. That is not material at all. Existence of the police complaint is accepted. And that is marked as exhibit. That is number 1, my lord. Next, your lordship will come to the.
Even you would say, perhaps, Mr. Sen, that even if D2 came forward, proved the document, Exhibit J, it would at the most prove that D2 made a complaint that the trucks are missing. But it will not establish actually whether the trucks are missing.
An insurance claim is not dependent upon that. Because then when everybody will have to wait till the police gives the report. Not even that. A mere police report is also not sufficient. Then the question will arise. That also will not suffice if they go to that extent. Your lordship knows, once an FIR is registered, that is only a preliminary. Then the police may give a charge sheet. It only proves that a trial will commence. Police may give they close the matter. Then the question of Naraji. So the insured will have to stay its hands. The insurance company will stay their hands and say that until and unless the fact of loss of the complaint is proved, we will not give you the claim. That, my lord, with the greatest of respect, is not the scope of the insurance contract. You will have to proceed on the premise of the subject matter being, unless I said there is an exception, you find that the truck is running after 1 month. You immediately tell me that you have completely, you did not even wait for the police report. Your complaint is false on the face of it. These are the documents. We repudiate the policy on the ground of suppression. Claim made under suppression. Matter would have ended. So, my lord, this is on the aspect I will before next, my lord, kindly come to the next paragraph with regards to the accident now. Kindly see paragraph 8 of at page 41 dealing with paragraph 7 of the plain. This is the paragraph dealing with the accident. It is stated that answering respondent has no knowledge about entering into any contract for carriage in the plaintiff number 2 or the case of entering into the contract. It is denied that loading of the oil into the tanker, transportation, all acts or obligations of the defendant number 2. It is stated that the plaintiff cannot avoid its responsibility about loading of the oil into the tanker, transportation, and further acts. It is pertinent to mention here that the plaintiff filed a case before the Consumer Dispute Redressal Commission with number such and such. Plaintiff specifically pleaded that the plaintiff made inquiries with regard to credential of the carrier, that is the defendant number 2, in the market, and upon inquiry, the plaintiff was satisfied that the said carrier possessed all necessary documents for carrying. Here in the plaint, the above specific pleading has been avoided purposefully to suppress that from the certificate issued by Government of West Bengal, Motor Vehicles Department, Burdwan, and Office of the Controller, and the Chief Controller. It became evident that the vehicle and the tanker through which the oil of the plaintiff was being transported did not have the capacity to take load more than its official capacity. Tanker could not take a load of 27 metric ton of cargo as stated by the plaintiff. While deciding the load of cargo, the specific gravity of the oil was also taken into consideration. His answering defendant is not liable to pay any money as insurer to the plaintiff, as the plaintiff intentionally suppressed actual carrying capacity of the vehicle and the tanker to the answering respondent while effecting insurance after taking the policy of insurance. Although the plaintiff had the knowledge about the carrying capacity, being the tanker admittedly by verification of the registration certificate. Non-disclosure of the plaintiff to the answering defendant about carrying capacity of the vehicle in the tanker tantamounts to willful misconduct on the part of the plaintiff. Plaintiff thus tried to defraud the answering connivance by making a claim of higher quantity of cargo which was not possible to transport. And the tanker through which the oil was claimed, it was not possible for the vehicle and the tanker to carry more than the permissible limit. Made survey in respect of the claim of the plaintiff and subsequently reviewed the same and informed the plaintiff that the plaintiff could come with the acceptable documents from evidence certified by concerned authorities that the vehicle and the tanker carrying the consignment that's claimed to be dispatched had the capacity to take load of 27 metric ton of cargo, the claim could be reconsidered further. Plaintiff failed to furnish documents duly certified by the concerned authority. The tanker did not have the capacity to transport the quantity of cargo, and the claim made in this regard was fully correct. It was properly repudiated. Surveyor also reported there was a gross negligence on the part of the insured. Cause of the accident might reasonably be attributed to overloading of cargo in the tanker in the lorry. Therefore, loss did not come under the purview. So, my lord, what I want to say from here is, my lord, now kindly see, sorry, next page, my lord, taking all the aspects of the matter into account, answering defendant rezoned liability under exclusion clause 2.1. This is their case in the written statement. That is what, my lord, the learned judge has said. You have to prove the breach. That it comes on, that is what Delhi High Court, Supreme Court, my lord, that is why what I relied upon that. This is your case in the written statement, that you have justly repudiated the claim taking recourse to the exclusion clause. 101 is your liability now, section 101 of the Evidence Act. This is your positive case. So you factum of accident is accepted. Therefore, your obligation is to prove accident occurred due to overloading and no other reason. Suppose, my lord, the accident was the fault of the driver. Then it will not be covered by an exclusion clause. Suppose, my lord, from the other side, my lord, it had any other on a head-to-head collision. Then there is no question of overloading. So, my lord, who will, may I ask this question now under 101? My lord, with the greatest of respect, the learned judge has posed the correct question. You are relying upon the exclusion clause to avoid the claim under the policy. Burden is on you. And now, my lord, kindly see, my learned friend wanted to rely upon my witness's answer. Kindly see that document. What does it say at the most? My lord, kindly have a look at page 181, which is the exhibit W. May I place this document very slowly, madam? Your Lordship got it?
Yes.
Kindly see what is the tenor of this document. On the basis of the document submitted by you and the relevant survey investigation report, it has been without prejudice concluded, not final conclusion. It is without prejudice. I do not know it is without prejudice to what, but it is without prejudice. It is not a final determination. It has been without prejudice concluded two things. Number one, though the transporter did not deliver your cargo of rice bran oil worth rupees such and such under different consignment notes, neither informed the police authorities nor initiated any legal action against the transporter. That is number one. Number two is, it is difficult to accept. But I come to the number two later. So they say they conclude without prejudice that we have not informed police authorities or initiated any legal action against the transporter. As a matter of fact, police complaint was not against me. I did not file the police complaint. It was filed by defendant number 2. That is their case in the written statement also, that these are conduct which are not a conduct of a reasonable and prudent insured. That is your case. So, my lord, if my witness has said yes, it is correct, what is the effect of this? It is in consonance with my case that the transporter has lodged a police complaint. And what is the admission which my learned friend wants the court to look into? The police complaint is there. It is already on record. So even if but he has not said anything incorrect when he says that yes, I agree that we did not inform the police authorities.
And also, I agree that it is difficult to accept that.
Now I am coming to that. Number 2 is, second conclusion as recorded here is, let us read the line. It is difficult to accept. Insurance company feels that it is difficult to accept that 3 tankers certified to carry far less quantity of oil were carried. It is difficult to accept. It means it is difficult to believe. That is in my favor. Insurance company is probably trying to say that it is difficult to accept that you had unloaded more than the carrying capacity, or the tankers could carry more oil loaded onto it in excess of their capacity. It is not a conclusion that it was carrying. It is in the nature of a improbability. It is not possible to accept this fact. So what is the wrong in my witness saying yes, yeah, I agree. The witness also said it is difficult to accept this, that we had loaded more than it could be, then it could have the capacity to carry.
Yes.
So this does not shift the burden of 101 from them. When they are saying that it is difficult to accept, well, now if they are repudiating the policy on that ground, it is this sentence or this opinion of the divisional manager is in the nature of an opinion. I am thinking aloud that possibly the tanker has a certified weight. It cannot carry more than that. Now, if you have to cancel repudiate my claim, and you are saying that I have in fact loaded more, therefore I am guilty of willful misconduct. Therefore, somebody has to prove that. It's a fault on me. You are alleging I am guilty of willful misconduct. Burden has to be discharged.
Mr. Sen, we'll just ascertain if learned counsel who are appearing in the 1245 matter are here. This is that appealability.
Yes.
Yeah. Oh, we'll not take it up today.
Kindly fix it next week any day, Milad. I have some difficulty
Yes,
on the next week any day.
Monday
Please file the notes for the for my case.
for the micas. Yes, you can file the note.
Just a copy and find it.
Share, circulate copies. 12:45 তে order করে দাও তো। We are informed that Mr. Bhattacharya, learned senior advocate and amicus curiae, is indisposed and therefore not been able to attend court today. However, his learned junior files the written notes of arguments along with copies of authorities that learned amicus curiae would like to refer to. Paragraph as jointly suggested by learned advocates for the parties, let this matter stand adjourned and we listed again Monday.
Monday is 21st July. My lord, if it could be done.
You will not come to court. If we find you in court on that day, 23rd.
He'll be through this.
No, this thing, virtual thing doesn't work.
আসবে একদম।
Then when? 22nd?
Third.
23rd? Go to the 23.
No, what is adjournment? Let's do it.
ওই দিন শোনো, ওই দিনও তুমি দেখো খালি আছে তো, মার্ক 12:45. Yes, Mr. Sen.
So, my lord, insofar as page 181 is concerned, my humble submission is my witness saying that the statements of document are true and correct makes no difference at all. It does not relieve them of their burden under section 101 of the Evidence Act. Because there is no fact asserted in this document. At the most, it is an opinion of the senior divisional manager, which opinion is rather in my favor, I will say, that it is difficult to accept that it can carry tankers certified to carry less quantity or carrying oil in far in excess of the capacity. It cannot, he is trying to say. Then kindly see, well, this is the letter of rejection, and they say if you can come back with acceptable evidence duly certified by the respective authorities that the tankers had to take the load as declared by you, the claims may be reviewed without prejudice. So, my lord, so this is not an assertion of any fact which my witness, by saying that yes, I accept the statements, it could mean the end of my case. Now, my lord, the next submission was with regards to the survey report. Kindly see survey report. Your lordship will kindly see. Kindly comes once to the cross-examination by the. They did not adduce evidence, but they have cross-examined my witness. So, my lord, if your lordship kindly comes to page 91 of the paper book, first volume. '91, kindly come to question number 193 onwards. This is cross-examination.
Plaintiff produced only one witness.
Yes. This is part of the cross-examination.
Yes.
193, the question is, was any surveyor appointed by the insurance company? Yes. Are you aware whether any report was filed by the surveyor? Yes. Did you get the copy of the report? Yes. Is this, kindly note the tenor of the question. Is this the report of the report dated 18 September 2004, which you have disclosed in this proceeding being PD number 21, appearing at page 41 of the brief of documents? Yes, this is the final investigating Crump survey report. So after this, can the court say that the document will not be looked into? This is there emanating from them, put to the witness by them, and not saying what is this document. They are not disowning themselves and asking them. They are putting to the witness that is this the survey report dated such and such. So it is your positive case which is being put to the witness regarding existence of the survey report. Now, my lord, kindly see. A 200. According to the survey report, local transport authorities were not informed about the accident. So, my lord, why I am saying this is, contents of the survey report has been relied upon in cross-examination. What is the value, your lordship will kindly consider? Is it therefore, you are saying, not only is this document a survey report, you are asserting the contents of the survey report to the witness.
Yes.
Next, my lord, what I want to show is Exhibit N, which is page 153. The 153A is a typed copy. Kindly note, my lord, this document is Exhibit N.
Yes.
Kindly see the first paragraph. We forward herewith the final survey cum investigation report along with minute and other enclosure received from such and such surveyor cum investigator Ranchi relating to loss dated such and such to accident of tanker number such and such. So, what I am trying to argue is, survey report according to them was not marked as an exhibit. Survey report forms part of a document which is marked as an exhibit. It is like a letter is marked as an exhibit with all its enclosures. So therefore, it is not, court cannot say, I will only look into the covering letter and not documents forming part of the letter.
This is it. I'm sorry. Item number 14 at
Item
page
number?
206 of the judgment list of eligible.
I'm talking about the letter only.
It does not say with enclosure. I wouldn't have wasted court's time.
I am on the letter itself. On the face of the letter, I am saying. Where is the cross-examination on this letter? It was incomplete. Cross-examination is otherwise. So how can, my lord, the insurance company at the argument stage and the appellate stage come and say, no, the court should not have looked into this document? You have confronted the witness with that document.
Still, the other question remains:
Yes, my lord.
the truth of the contents of the report.
Yes, yes. I am alive to that, my lord. I will come to that. Now, now, my lord, let's see. Kindly see this letter once, my lord. Exhibit N.
Yes.
So here in paragraph 1, why I am replacing paragraph 1 is survey report was part of exhibit N. Number 2, my lord, this letter is actually replying to the points raised by the surveyor. If your lordship kindly sees just the previous 2 pages, page 152A, which is the last part of the survey report. Serial number 15, recommendation. Loss recommended such and such, subject to the following.
Yes.
Submitting vehicle registration book of tanker along with road permit, fitness, authentication of selecting Amrit transport, reasons for not lodging claim, producing Pritam Singh whenever so desired. Now, this I am answering here. And other things, my lord. Kindly see. First is, I am writing in serial number 1 that the claim under the insurance contract has been enhanced. Under point number 13 of the above report, while assessing loss, limit per transit has been taken as 12 lakhs and claim of excise duty paid of pension has been deducted from the total claim amount. In this connection, please note that the limit per transit location was increased to 15 lakhs by the letter dated 19 September 2003, copy of which is enclosed for your ready reference. Hence, deduction on this account is totally irrelevant. Excise duty, we have full expense. As regards point number 15, we enclose here with the following documents. Xerox certificate of registration and fitness certificate of the tanker number such and such. Xerox of trade license, professional trade challan of Amrit Transport. We have already lodged claim on Amrit Transport for the above loss. Xerox copy of claim letter on Amrit Transport along with registered AD card are enclosed herewith. Condition of producing Pritam Singh of Amrit as recommended is very funny and amusing. We are not police authorities who are empowered to call such and such. In his report, surveyor has made a remark that the insured was not behaving like uninsured. We have to state we on our part are constantly in touch with the transporter immediately after normal time taken by any transfer for reaching the destination was over. We continuously inquired from the transporter about latest position of tanker verbally as well as the night. Correspondence with the transporter are enclosed, which proves that aforesaid remark of the surveyor is not tenable. Now, my lord, my point before your lordship will be that, as I said, insurance company had confronted my witness with the surveyor's report, relied upon the contents of the surveyor report. They are suggesting to my witness from the surveyor's report. Is it open for the insurance company to say that surveyor report cannot be relied upon? It is again a ministerial act of to put one line after question number 199 that this is marked exhibit. My learned friend himself have cited those judgments that mere marking does not amount to anything. Here, I am saying how the parties proceeded in so far what is their stand on the document, what is the requirement of an exhibit. to identify a party's stand regarding a document, to enable the court either to rely upon the document, its existence or contents, or not rely on it at all. So, my lord, here, two things I say. Surveyor's document is already an admitted document insofar as the defendant is concerned. Not only that, in a document which has been marked exhibit, I have written to the insurance company annexing the surveyor's report and giving my points on the surveyor's clarification. That is also on record, marked as exhibit. So if the insurance, now what is the stand of the insurance company in exhibit W? They have not also accepted the recommendation of the surveyor. They go on a different aspect altogether. But they have not discharged their burden by exhibit W or thereafter to produce document to show that I was carrying more than the permissible limit. That would not have been sufficient in my respectful submission. It was on them to prove that accident because of that. Simple overloading will not discharge their burden. Accident is an accepted position.
And this is only in respect of one truck.
This is in respect of one truck. Regarding the other two trucks, as your lordship said, surveyor's report will not come into the way. So what is the document with which you came to court to show that my case of the two trucks being lost or untraceable is absolutely false, and I had made a misrepresentation to you? There is no document.
And Order 41, Rule 27 is not automatic,
Not automatic.
not as a matter of course.
So
Something which they could not have produced with due diligence.
and your lordship will also consider whether an information under Right to Information Act without any supporting corroborative document from that authority, statutory authority, to support the statements in that information is sufficient or can be relied upon. When the primary documents could have been available, insurance document, when we go for registration, they have all the documents with us, them. So there should have been documents to corroborate this fact, my lord. Now, if your lordship sees my repeat other documents which I have exhibited, there is not a single document which has come from them which says, my lord, that it is carrying more. Now, my lord, I just come to the judgment once, my lord, impugn the judgment.
On the contrary, they seem to be saying you couldn't have been carrying more.
That is what I'm saying.
They were possibly trying to repel a case of inflated insurance claim on the basis that you had loaded
More. And they are saying that you produce document.
Yes.
But this is going beyond their written statement. Written statement is, I am guilty of willful misconduct.
That is one aspect, Mr. Sen.
Give you document.
That is one aspect. The other aspect also, bear in mind, and I'm sure you'll address us, assuming there is no written statement.
Yes.
How far the plaintiff was required to.
Assuming there is no written statement,
Assuming it's an undefended.
my task again therefore will be On the basis of these documents, insurance contractual clauses, if your lordship then goes back to the contract, I am making a claim under this contract. What is it I am required under this contract to show? Valid live insurance contract. Subject matter is covered by the insurance. There is a claim made in terms of the contract within the time limit. I am not subject to correction, but I am not required to show that there was, at the most, these are supporting documents which I give in support of the incident resulting in the loss.
In fact, it is a kind of negative, this missing truck. It is not there.
It is not there.
How do you prove it is not there?
It is not there. It is steps which I have to show that my conduct is not willful, so that which may not give a ground for exclusion of my claim under the policy. So therefore, even if it is and my lord, these documents were on record, if they were not there. Exhibit W.
When you will continue after recess?
I have a matter at 2 p.m. my lord. I was just about to say that, my lord.
We have the only problem, Mr. Sen, is that then we'll have to take up another matter. That will also become hard in part.
I have more or less. I will take maximum of half an hour.
You take 1 hour. We don't mind about that. We don't mind about that. So when will you do it? Because firstly, it's fresh in our mind. Secondly, other matters will intervene.
Wednesday or tomorrow also, my lord. Tomorrow, if your lordship finishes the
Wednesday.
appellate side matters.
That's big if. We don't know.
But Wednesday, let it retain whatever position.
Unlikely to be touched because non-commercial comes first. And that's quite a long list.
If it retains its position, then the next commercial day, the matter will be taken up.
Friday that.
Mr.
Friday with the next commercial day.
Huh?
Next commercial day.
Ghosh, learned senior counsel representing the appellant, concludes his opening submission. Stop paragraph. Mr. Sen, learned senior counsel representing the respondent / plaintiff, begins his argument but does not conclude. Stop. On his request, let this matter be listed again on Wednesday. Wednesday, Tariq Dida,
The same position.
retaining his position.
Grateful.
Retaining it. Huh? Does not conclude on his request. Listed again on retaining its position.
Lordship, before rising, if I may, item number 1 was a passover matter. I am appearing for the appellant plaintiff, Lordship. Today I have to leave court after this 1 p.m. I am praying if not today, Lordship.
Not today, inform your other side.
Lordship,
Very
ready here, Lordship. Thank you. Much obliged.
Lordship, I'm appearing for the petitioner. I seek 1 week time to serve to the other side because there was too much of typing in the petition. So I just
Too much of?
typing for the petition. Like I need 1 week time to serve the paper book to the other side.
এটা কি commercial?
Yes, my lord.
Dinesh Kumar Chaudhary? Very well. On the request made by learned advocate for the appellant, let this matter stand adjourned for a week and be listed again on সামনের সোমবার করে দাও।
21. My lord, please. 21, my lord. 21, my lord, please.
21st?
Not 21st.
We have a problem on 21st. Stand adjourned for a week, Likuna. Stand adjourned and we listed 23rd.
Yes, highly obliged.
Item number 5.
The matter, my lord. This is arbitration. This arises out of family dispute. Two brothers. This is the section 9 of the rejection. So the injunction we were enjoying, it was vacated, application dismissed. When we moved the appeal, there was an interim stay granted with a 8 crore bank guarantee, and which we furnished. Now the final case. This is a case where 2013 there was a family settlement captioned as memorandum of understanding. March 2000.
All parties are represented.
Yeah, there are two sides.
Two sides.
Which provided for my group, that is the petitioner group, to be paying 28.5 crores of rupees, plus having all the personal guarantees of the respondents given to banks released.
Released.
The companies are in question are two. One is a company called MBL and another company called AAP. Now, what do I get in return for doing this? Is that I get 55 lakh odd shares which they were holding in MBL will be transferred to me, and AAP infrastructure company would be transferred to me. But
and what happens to the bank guarantees? You will become the guarantor.
No, I will get them released. So whatever.
So you will get them released.
They were the principal debtors, so they'll pay their
principal debtors, or yeah, whatever by replacing, I will get them released. This is in 2013 March. Now, this dispute has three parts. One is from March 13 up to the date when the matter comes to court, section 9. Then section 9 to the division bench order, and then post-division bench order. So so now the first phase, because there's three distinct phases. So far as the I'll give you 1 minute. Now, so 2013, the agreement contemplated that that this will be completed. This this March 13 agreement contemplated that it will be completed by
30th July 2013.
By 30th of July 2013. So within 4 months, 3 or 4 months. But nothing happens. 3 or 4 months, nothing happens. What happens is, thereafter, between September 13, so that is after there's no formal extension. From September 13 up to June 14, shares are transferred around 30 or 35 lakh odd shares out of 55 lakh shares are transferred. Several personal guarantees are also, around 8 or 9 banks are also released. From our side, we paid 24 plus crores, 24.9 crores out of 28.5 crores. And they also
you pay to their group.
To their group. They also resigned from the board of directors from this MBL. But 30 odd lakh shares are not transferred. Our case is that against which I was willing to give the 3.5 crore of rupees or 3.5 crore rupees. Proportionately, it is much less than the total, and get the balance transfer. But be that as it may, nothing happens. And instead, my lord, there is a lull till the time in 2017, there is this company MBL, the limited, the quoted company goes into corporate insolvency resolution process under IBC. And then suddenly, while the company is in CIRP, in 2017 comes a letter from them asking me to have the personal guarantees one personal guarantee remaining up, personal guarantee to be released. We write back saying I deny it, and under no obligation. But in 2020, but after the company comes out of CIRP in 18, in 2021, remaining bank guarantee, remaining personal guarantee to the bank for ARP's loans released to 2021 April and August, and they had also given their title deeds as security for ARP's loan. So that is also released, and they're giving back their personal title deeds. After this, we invoke the arbitration when they after this we demand specific performance of the balance shares in 2021 after we have discharged our obligations. So we then say that you come for settlement, or else we have to go for arbitration. This is in December 2022. 2021, the guarantees are released, the title deeds. 23 January, there's a refusal, and we come to court in April. There's a parallel saga which is their defense. In October 2013, there's another MOU between one of the companies, between one of the initial agreement of March 13 has two entities on group, my group, and 5 entities from their group. So there are 7 signatories to 7 parties to the agreement. 2 out of them, Prabhu International from their side, and from my side, MBLA Capital. There's another agreement for transfer of 17 lakh shares of this MBL for not a lump sum, but 63 lakh rupees, 63 rupees per share. October 30. And
by whom to whom?
They will Prabhu will transfer 35 lakh shares.
This MBL is different from same MBL.
No, MBLA, because a company can't transfer its own shares. MBLA, my group company, I mean, under my control, Anjani's control. So Prabhu will transfer MBL's shares to MBLA for 63 rupees per share. Now, there's also a clause for release of the guarantees given by Prabhu. By Prabhu only for the loans of MBL, not ARP.
No, but there was a first agreement, you said 55 lakh shares of MBL to be transferred by their group to your group. There, about 28 lakhs they had transferred.
38 they had transferred.
And thereafter, as you said, liquidation, this and that.
And then come back,
Yes.
they've revived.
Yes.
And there's October MOU, same year, where they were to transfer 63 rupees per share, 35 lakh.
Just 2 agreements in respect of same shares.
No, they're different. This is 55 lakh shares, this is 35 lakh shares.
I see.
Now, what happens thereafter, so far as this October 2013 MOU is concerned? The March 13 MOU is 55 lakh shares, then transfer of this company called Prabhu, no? Prabhu to be transferred to me. It's a large.
Prabhu or AAP? AAP.
I made a mistake. It's Prabhu.
Prabhu.
Prabhu is to be transferred to me.
All the other companies.
And all the related companies, all to be transferred for 28.5 crores. Prabhu MBL's shares, 55 lakh shares, some other related companies, plus certain other obligations like properties to be will leave the property, etc. While the October MOU is only for 17 lakh shares at rupees 63 rupees. October 13 MOU. October 13 MOU, as per our case, was never performed. Not a single share at 63 rupees was transferred. And I'm calling us we because even though that's MBLA, but I'm lifting my veils because that was the charge that I should do, hide behind a veil. No, let me treat it as we. So in March 2015, we, that's the MBLA, filed a specific performance for the October 13 MOU in the High Court. In the specific performance suit, they come and interim application is filed that they should not transfer those shares to third parties. I'm calling them because though it is only Prabhu out of that group, but Prabhu comes and resists the suit as in the suit on the ground that this October 13 MOU is void agreement, contrary to the Securities Contract Regulation Act, unstamped, etc. But the interim order is passed in our favor. And their points, their arguments are recorded in the interim order. And in the meantime, while this applications are pending, MBL makes a bonus issue. 1:1 for each share. And then they take the point that the injunction doesn't apply to the bonus shares. So MBLA comes to the suit court again, gets an order of injunction on the bonus shares. This MOU of October 13th was for a period of 1 year. 1.5 years.
Then it was extended for another
It was thereafter extended for another 1 year till October 16. And the parties, as per it seems that they were trying to settle the issues. This is the 2015 bonus shares agreement being extended. 2015 and my brother dies. So Ram Gopal and Anjani are brothers. So the fight now is between myself and my nephew. This suit, injunction confirmed, and not injunction as status quo, it was modified, and then the suit remains pending. No written statement filed. After we got back the title deeds for them and the last bit of obligation from our side, having the personal guarantees of ARP released for ARP's loans, that's my company. Then that's in 2021 August. Suddenly, in September 22, in the meantime, MBL comes out of CIR. And its share prices again naturally go up. In September 2022, they write to us that you specifically performed the agreement for which we had filed this suit. We are not agreeable anymore. The share prices had gone up. So we do not accede. They make an application in the suit for specific purpose. We say it's not maintainable because they have not, you have a counterclaim also. But none the same, we withdraw the suit. We are no longer interested, let's be clear. So that's it. So that is sometime in March 2023, the suit is withdrawn. After they filed that application when we were no longer interested in continuing with that agreement. You have a right to make it.
That application was filed only at
And our case is only after I invoked the arbitration in the March 13 agreement that suddenly the application was filed in the suit for specific. Then comes, my lord, after the suit is withdrawn in April 2013, we file a Section 9 application in the arising out of arbitration, because we invoked the arbitration clause sometime in December 2022. They write back refusing in January 23.
This is the March agreement.
March agreement. October agreement, we have withdrawn. They have now filed an application for restitution and for restoring the suit. Because of injunction, they are saying they had suffered loss. They could have sold off the shares, rightly or wrongly, in violation, but then they were prevented. So that is being heard by the interlocutory court. Now, so thereafter, when they refuse to, when they categorically say, I will not go to arbitration, we nominate an arbitrator, senior member of the bar, and we file a Section 9 application. That is in April 2023, we filed the Section 9 application, and on the first day, that is in April 2023, 19th April, when the matter appeared before Justice Saraf, I did not press for the interim order, because from 2013 to 2023, there was nothing transferred, and there was no urgency also. I can't say I've come after 10 years and there's urgency. And I didn't press it. Affidavit directions are given. And the matter made returnable on 6th of June 2023. I'm giving the details because it's a better relevance. 6th June 2023, they come and take extension of time to give the opposition. It's fine. On the 6th of June 2023, they upload certain returns. There's a story to it, from where it appeared that they have transferred around 2 lakh odd shares from out of the remaining 18 lakhs or so shares as per the MOU of March 30. Then we come rushing to court. So this is not proper. You take extension and you take directions, and nothing has happened. So, and Justice Bhattacharya then, Moshini Bhattacharya, then in June 2023, passes a status quo order. In fact, status quo is that you restore the position back, as was on 6th of June, when you came and took direct extension of time to file affidavit. And no further transfer. They have not restored it back, and the matter was heard, and the matter was kept pending till such time as 25th February 2025. In February 25, Justice Kapoor dismisses the application. This is the short compass in which the facts have happened.
The arbitral tribunal has not yet been constituted.
We have filed Section 11. The matter has been heard at length. They are opposing very strongly. Matter, Justice Shorkar has heard it. I think kept under the heading for orders. We thought that the hearing was concluded, but then it's appearing as for orders because we've given our notes, but it's appearing in the monthly list. Possibly His Lordship had said once, if depending on what order the division bench passes, maybe it'll become easier for Justice Shorkar to then do her part. So, and being a practical judge as leadership is possibly is hoping. So that's the other reason why we are also very keen to do this. Now comes, so the post Section 9 up to the dismissal, there is this saga.
That is called passing the buck.
And the buck stops here.
Yes.
So this was between Section 9 filing and the saga was that they were transferring the shares, so it was injuncted. Now, in February 25, the order is passed. We filed the appeal within 2 or 3 days thereafter, and the previous division bench passes because they said that their shares are also worth something. So, upon furnishing a guarantee of any other form of security, the interim order will revive. So we furnish a bank guarantee for 8 crores of rupees to the satisfaction of the registrar.
Today you are enjoying an interim order.
And they're also having their claim 8 crores secure. But my trouble doesn't stop here. Not at all. My lord, 2 things happened thereafter. My lord, week come to learn that they are not really interested in the security. So they know we are a solvent party and they have received 24.95 crores. And in between, when they sold 2 lakh odd shares, they realized another substantial amount of money. So they start writing to the bank. Why did you furnish the guarantee? The company, MBL, banker has given the guarantee.
MBL's banker.
Has given. They are concerned with their security. I may beg, borrow, steal and get the money and secure the dues. They have no right to say that I have to get the money from.
How much shareholding they have in MBL now?
That remaining 17 lakhs plus 17.5 lakhs, 17.5 lakhs or so, plus bonus shares. If they have a right, they can go to the.
They are still the majority.
No. 3%. If they want, they can still. Now they go to the tribunal. They now, unlike previously, now they can. Now the waiver is given. Doesn't have to have 10%. It can be waived.
Currently, they are holding 21 lakh shares because
21 lakh shares they are holding. Whatever. But as it may, they are not concerned with how I furnish the guarantee. The bank has guaranteed. Write letters to the bank. We then make an application. Said if your aim is not to have the claim secured, if you ever try to achieve an oblique purpose, then let the security be returned to me. Because we have discharged our obligation. This is oblique motive. We've taken the security, so it should return to me. At this point of time, 2 things happened. One is, out of that remaining shares, 21 lakh shares, so 5 lakh shares they had pledged with a bank, with Central Bank of India, for a loan taken by one of their family concerns. In fact, the October 13 MOU covers this 5 lakh shares. And one of the obligation was that they have to get the pledge discharged. That was also our case is our case in the suit and now the restitution proceeding, that they never got their pledge also discharged. This company called Prabhu had given a guarantee to the central bank for 3 crores of rupees, for which these shares were pledged. It is solvent company. Suddenly we find that these shares are sold. But the bank, central bank, has sold the shares for 4 crore plus. So the pledge shares, which is supposed to come, if at all the October 13 MOU is to be enforced, which I am saying, of course, not subject matter of the suit proceeding, the pledge shares are gone. And the injunction applied to all the remaining shares they were holding. The pledge shares are sold for 4 crore plus, as per the quoted price. This is a quoted share. So we make this application. So we make an application covering both, that they have got this security without having any intentions to secure their claim, but to harass us. Secondly, their personal guarantee, their own company's liability to the extent of 4 crores has been discharged by selling these shares, which was supposed to come to me. So another 4 crores you have recovered. So you have recovered well more than 30 crores, 29, 30 crores. So both composite, I make an application. And they make an application that...
You make an application under Section 9?
No, we make an application, the appeal, that for vacating that condition put for furnishing the guarantee. That 8 crore, it should be unconditional stay. For 2 reasons. One is that they are for oblique purpose, and secondly, now they have recovered more than 30 crores. More than 20.5 crores. That is the consideration amount. They have recovered around 30 crores as per this agreement. And they have, in pittance, though I can't say they have violated the order, because there is it's an involuntary sale if the bank enforces the pledge. But it appears that the bank has, this was done in consent, because for 3 crore personal guarantee given by Prabhu, 4 crores worth shares have been sold. So 1 crore at least has come extra. Secondly, this is for their own personal company loan. Their guarantee is being released. So it was never in default. And this could have been, this according to us, was done at their behest to indirectly get around the order. They are, of course, saying this is an involuntary transfer. And whether there's a second 176, 176 or 174, 170 of the Contract Act, that the pledger's obligation to give a notice. We have called upon them to say whether the central bank gave a notice, because otherwise, if this was involuntary invocation of pledge, check for 176 or 175.
Have you ever tried mediation?
My lord, please. My lord, please. I find it very embarrassing to come back to the court and say I failed. Because that's the whole difficulty, my lord. They may have made the attempts were made, but then please don't tell me. Send to anybody you want to, but not me. Please, because it's the only reason I don't like to come back to the court and say it's not possible. I have to say that tomorrow Calcutta Swimming Club case. And it's very awkward for me to come and say that they sat in my chamber and I'm told it's not possible.
No, not in your chamber. I mean proper mediation.
Proper mediation. No, I mean mediation means I tried to settle. No. I was appointed mediator once by the National Company Law Tribunal. I couldn't succeed.
No. We have our mediation center, full setup.
Ultimately, same thing I've done there. Ultimately, I am a mediator. Whoever is a mediator, I possibly lack the skill, or whenever
Uncle and nephew, they are fighting.
I know that, Lordship. In fact, Justice Bhattacharya had said, try to say.
Inures to nobody's benefit. Well, I shouldn't be saying that.
No, my lord, it inures to some benefit. That is why this is being dragged on. An agreement which was dead has been resurrected after 13 years. So, my lord, mediation, perhaps, my lord, I am seldom ad idem with my learned friend, but I am ad idem that he may not succeed, because, my lord, our case is, this entire conduct is fraudulent, and there is prima facie finding to that effect.
Very well. Then we'll have to hear it.
But here also there was mediation attempt that go out of court, and they went to somebody, to a family elder. I think there was some correspondence and it didn't work out.
So there are 2 applications in the appeal.
As I submitted the first when it came, really no point having the applications heard, because the appeal is disposed of now. And Lordship, may I our completion kora achi? Completion achi? Paper book. Lordship, I have to place it now. This is the broad overview. Now I have to place the.
Shall we go through the order once, or? Yes. Dauto?
So put it order now.
Who was the respondent number 3 before the...
Prabhu. Achha.
So they were group 1.
They were group 1. কোথায় যেন আমাদের চিঠিগুলোকে নোট করে নি আমাদের এখানে আছে।
This, Mr. Chaudhary, this payment of rupees 24.96 crore, as they say, that is disputed.
Yes. Because according to us, that was again shares purchased in the open market.
Money
they are-
payment not disputed.
And their chart will also show that. They have purchased it at higher rates, 200 rupees, 800.
Yes, Mr. Mitro.
May I start? The few basic points of Justice Kapoor's order, which seems to have gone against me.
Before you proceed, roughly how long you will take? Because I don't want to detain your learned senior friends. And
I was just inquiring, hoping that there'll be a 3:30 fixed matter or something.
is there any fixed matter today? No.
So then, of course, I will. I will come. Yeah, sure. I will. It will take me time.
Take time. And you will also take some time. So we can, Mr. Mitro, Mr. Joyanta Kumar Mitro. And others. Yes.
A few basic things where Justice Kapoor, according to me, has gone. I can agree with his lordship is, with all due respect. Is one is his lordship has proceeded on the premise that Prabhu is admittedly not a party.
To the MOU.
That is factually wrong. That is on the, if the MOU you read, Group 1, Prabhu is the third or fourth party. Is the fifth party, and it's even the signature part of the, including Prabhu, for entire Group 1, all the directors and shareholders. There's only thing which is not there is the rubber stamp of Prabhu, but all the shareholders and directors have signed saying that Prabhu is the party. The second premise is that, as Mr. Chaudhary also harped on, shares were in fact transferred at 89 to 200 something price per share. So can't be as per the MOU. This is a quoted company. And share transfers, even with promoters, have to be through stock exchange. That is why the MOU contains a specific clause that the shares will be transferred either by transfer or gift. And out of this 35 lakh shares transferred, 20 lakhs, and that's why gifted. So as to ensure that the total price comes to this. And the open market transfers, which he's talking about, yes, it's through stock exchange. But the only catch is that, difference is that, unlike a normal share transfer where the buyer is seller blind and seller is buyer blind, the stock exchange especially. In this case here, this was pre-arranged sale. So, and being promoters, returns had to be filed in advance before the sale is effected, and then after the sale is effected. And all these open market sales have been specifically signed by them and by my clients, returns filed to SEBI, which are part of records, as inter-promoter transfer. Inter-promoter transfer, but they had to be, whenever there's a sale, it had to be at the quoted price. So, and had to be through stock exchange. With the returns, inter-promoter transfer, and bulk by gifts, by gift deeds after the MOU. So that's what his lordship has possibly overlooked, that part. That the transfers, so it balances out to a much lesser amount. Share prices varies. The other point is that the agreement has never been performed after July 13. Here, his lordship was also kind, with due respect, has overlooked the fact that all the share transfers, which according to us, and as per the returns also shows, have happened after 13. All the personal guarantee release have been after July 13. Their letter is there in 2017 asking us to release the guarantee. Of course, I refused at that time, but their letter is there. I am as a guarantor, they are equally liable to the bank. They were. But we got the guarantees released in 2021 also. And their title deeds and returned to them. But nothing happened till July 13, and thereafter only it happened. October 13 MOU, at least here, this is shown. According to us, October 13 MOU was never performed. We had filed a specific performance suit, that's why. It was not their case in the specific performance suit in the I will place the orders that it is partly performed. They were saying the agreement is void. October 13 MOU, 63 rupees 75 paisa per share, but single share transfer. So and his lordship has talked about supersession. At the same time, lordship has also noted that this is purely an issue before the arbitrator. This is not 9 court or 11 court. I mean, after Sanjeev Prakash judgment and even afterwards, even more so with the Coxon case. And especially here, there legally can't be a supersession unless you lift the veil and you go much beyond and after evidence. There's 7 parties to the agreement, 2 and 5. Out of that, 1 and 1 sign another agreement in October 13 on different terms. And no mention of any, there's a mention of any earlier agreement being superseded or modified, nothing. Legally, 2 persons can't supersede 7 persons agreement. And secondly, if you say Prabhu is not a party, Prabhu is not a party to the first MOU, that is his lordship's finding. So how can the second agreement, where Prabhu is a party, supersede the first agreement? His lordship's finding that Prabhu is not a party to the first agreement. If that is so, then this is mutually exclusive. I can't supersede an agreement to which I'm not a party. Oh, yes. Prior to I said corrected. Prior to, there are altogether 6 plus 14 guarantees and 28 crores to be paid by July 13. Money out of 24, nothing has been paid before that. 6 out of the 14 guarantees were released before July 13. And all the rest have been 14 up to 21. All the rest 8.
And you were instrumental in release of
Yes, there's no dispute about that. They did not pay a single farthing to get the guarantees. No dispute about it. Now, fraudulent conduct is the catchword of the other side's case. Fraudulent conduct. What is my fraudulent conduct? What is my fraudulent conduct? I asked myself this question. I did not invoke the arbitration as his lordship has found only after they applied for withdrawal of the suit. Only after they applied for specific performance in my suit. I invoked the arbitration agreement in December 2022. They made that application for specific performance in March 2023. And
they applied in that
my suit, specific performance suit.
After that, you withdrew.
After they withdrew.
It was a 2-tier arbitration, 13.2 because it was negotiation of
So my arbitration I invoked in December 13. January 13 was their refusal.
You have a list of dates.
Yes. But this is too comprehensive. All make a shorter one. This is far too complicated. Give without the forms. The form, each and every return is mentioned here. That gets because this is all of the return, all the 10-3 rule, SEBI transfer takeover.
I have a list of dates. I'm giving one to my. If he wants to add any, he can add that.
I hope it
Kindly
is not, as Justice Banerjee would say, favorable list of dates. Mine is too comprehensive, and I hope it's not a
Well,
favorable.
that it is very short.
Very short scares me. Anyway,
He is bound to be scared either way, man. He has a
I
scary case.
am always scared. Where do a matter, I never but scared. Unless I'm for a bank and money lender advance is the case. And
And he shoots not with one hand, with both hands.
Shabbashachi. No, my lord, here, lot more have to come. Lot more. A lot more. Or she may start with after all, our whole genesis is the MOU. Or she kindly comes to the March 3rd. I will bring next day the list of dates shown of all the returns, because that returns that around 20 returns to there were 20 20 returns. 20 returns filed, all the 20 or 25 returns are separate. Or should kindly comes to the first volume, page 29. এইটাকে ওটাকে একটু unfavorable days গুলোকে add করে
What is your application for in the appeal?
My application is my
We need to know about it because
guarantee be really
no, His Lordship hears out the
we
appeal.
are hearing out the appeal.
Because my lord, mine application was in effect, my lord, what he has done is that the target company for the shares of which all these things are happening, he has, my lord, on one breath he is saying I have nothing to do with the company, I am an individual, and from the very same company the money has been put in. In effect, my lord, and we are talking of share valuation and valuation of the share price. He draws the entire money is put in over there.
That's MBL commercial.
Yes, that's the target company. And in effect, my lord, the shares, the worth of the company is getting depleted if you give that. So effectively, my lord, if he is fighting where a shareholder, he has to choose, my lord, in what capacity he is fighting. Whenever it's convenient, he is saying company is me, I am the company. And whenever it is inconvenient, just as over here, he is saying I am an individual, I have nothing to do with the
I've
company.
never
have
said that. I've
I
always
show his pleadings, what he has said.
from the beginning I am saying, I'm calling myself we because MBL on that date, March 13, when the MOU was executed, was already under my control. But they held a large block of shares.
So if he says that, if what Mr. Mitro just now said, then the company filed a suit, got an order of
That's
injunction,
MBLA. But that's
Now-
also
now-
we. That's also
Ah,
we. I'm
that-
saying that's we.
got an order of injunction.
That's a
When the
different
shares, my lord, when the share prices were 200 rupees and odd, injunction was granted. When it started falling, my lord, we write repeated letters, you take the shares you want to. For 8 to 9 years, my lord, they continue the advantage of the injunction. I make an application for judgment upon admission, my lord, they withdraw the suit. So I have now filed an application for restitution that I am entitled to. It is settled law. On the date of injunction, what was the share value? Now, when they withdraw the suit, the earlier injunction order also goes. Then they resurrect the 2013 March agreement. Section 9 is filed and that is done. And my lord, it is incorrect to say that they invoked the arbitration earlier. I show, my lord, our letters are much earlier. Because they got to know this is what we are going to do. We are going to withdraw the suit and do it. Absolute fraudulent conduct.
She kindly comes to page 29. This is the MOU of March 30. What you kindly sees group 1, that is 125. 125. 4 are individuals. Ram Gopal is my late brother, elder brother. While he was there, things did not come to court. This whole thing happened after his death, because he died in 2015, and then the things became. Ram Gopal, Maruti, Aditya, and Anuj. Ram Gopal is no more. Aditya we did not impede because he has discharged his obligations. Maruti, Anuj, and Prabhu. That is group 1. And this side it is Anjani Lakhotia and MBLA Capital.
You're all brothers or cousins or what?
Ram Gopal is the elder brother of Anjani. Number 1 is the elder brother of number 6. Number 6 is my client.
No, Lakotia,
Well,
Maheshwari.
that's
I see, but they are brothers. They are all.
own blood brothers.
Originally, all are Maheshwaris.
Okay,
Lakotia is a the trade name became popular and
I see. Correct.
something to do with
And MBLA Capital is a company under my son's control. I take it as my company. Number 6 and number 7. Now, Lordship kindly sees D. First party of Group 1, fifth party of Group 1 is a closely held company of the first party and his family member. So it's admitted that Prabhu is a family company of 1 to 4. Second party of Group 2 is a closely held company of the first party. So there's no question about anyone claiming independent right. Now, Lordship kindly comes to M. Recital M. The fifth party of Group 1 is the legal and beneficial owner of 31 lakh shares, equity shares of rupees 10 each, fully paid up of MBL, representing 18.04% of its issued equity paid up capital in demat account. Prabhu. Now, N. Group 1 is desirous to exit from the company by way of transfer of the Group 1 shareholding as set out in this MOU in MBL to Group 2 in accordance with the terms and conditions and for consideration and in the manner hereinafter contained. Exit from MBL. So the company is meant as MBL, that is mentioned where it's called company is MBL. Where is it?
Yes, that we have seen.
Yes.
That is F,
F,
capital
sorry,
F.
thank you. I just missed that. I missed that. Yes. MBL. Now, Lordship kindly come straight away to one is the 55 lakh shares at 1.1. The members of Group 2 agrees and acknowledges that the first and second party of Group 1 have given the following personal guarantees. Consortium banker of the company MBL for securing the fund-based and non-fund-based working capital facilities, and to the banker of ARP Infrastructure, a subsidiary of the company for 50 crores. Now, Lordship, 1.2 is very important, Lordship, considering that the total consideration which is mentioned afterwards at 28 crores is very important. The Group 2 shall arrange for release of the personal guarantees of parties of Group 1 by or before June 13 or within 60 days of resignation from MBL, whichever is later. 2. Pay and or cost to be paid to Group 1 in all-inclusive consideration of rupees 28.50 crores for the shares as set out in clause 1 above. The parties of Group 1 shall ensure transfer of shares by way of deeds, documents, including transfer deed, give deed. This is the giveaway. You quoted price, so that's why give deed is like. To ensure that the total shares as per clause number 1 are transferred for a total consideration of 28.50 crores. The consideration may be shared, distributed between the parties of Group 1 proportionately or otherwise, as mutually agreed, subject, however, that the net aggregate consideration amount shall not be higher or lower than 28.50 crores. Group 2 and Group 1 are indemnified so that no liability. Now, Lordship kindly comes. 1.4 consideration shall be paid to Group 1 as per schedule above, and thereafter Group 1 shall transfer the shares to the demat account of Group 2 or to his order, and or to his order in proportion to the amounts paid together with all records. Proportion to the amounts paid. If one goes by that, I have to get another 7-8 lakh shares. 1.5. Now, Lordship, 1.5 and 1.6 are also important. Parties of Group 1 shall relinquish, transfer, assign, and surrender all their rights, entitlements, authorities, interests, power, whatsoever in relation to the company and or its subsidiary company and or its associate joint venture companies in favor of Group 2 and or its nominees. The parties of Group 1 shall transfer all their shareholding in Prabhu International to parties of Group 2. So Prabhu also comes to us and resign as directors upon receipt of consideration. Resign as director. Bonus share kothay ache? Yes. 5.2. 5.1. 5.1 is the undertaking. The parties of Group 1 jointly and severally expressly undertaken that they shall not dispose of, transfer, or encumber the shares in any way except as has been contemplated under this MOU. However, members of Group 1 will be free to deal as per their wish with their respective shareholding if the consideration as defined in Clause 2 is not cleared by 31st July 2030. And that the bonus shares is also made part of 5.2. 6.2 and 8.2. And 6.2, the personal guarantee is released. 8.1 and 8.2 is important from the perspective of Prabhu being a party. 8.1 and 8.2. Representation of and warranties the parties of Group 1. 8.1. He has the legal right and full power and authority to enter into these presents and to execute and deliver and to take any action and execute any documents required by the terms hereof and to execute and deliver and 8.2, he has the legal capacity to enter into and perform these presents, and those presents constitute a legal, valid and binding obligation of the parties of Group 1, enforceable against the parties of Group 1 in accordance with its terms. And Lordship has seen the issue required, either party shall cause to have the same amendment with the written consent of the other party. And Lordship, for amendment novation, there is a separate clause, Clause 12. Clause 12, page 37. The party shall comply with all statutory obligations and as may be required to be complied with under the laws of the country. In case any inaction is required to be taken, is required to be done by either party, both the parties shall endeavor to do the same. If so required, either party shall cause to have the same amended with the written consent of the other party. However, the consideration as set out in Clause 1.2 above shall remain unaltered. And the arbitration clause is a two-tier arbitration for settlement. Now, my Lordship, the October MOU is at page 62. 262. 262 volume. Can I put gift for Can I gift for No, I can't gift it. Now here 263 A. Seller is the owner 263 A. Seller is the owner of 17 lakh fully paid up shares of MBL Infrastructure, listed company. B is important. Of the said 17 lakh shares, 5 lakh shares have been pledged by the intending seller to Central Bank. Now, Lordship kindly comes to 2.1 and 3.1. I'm not placing everything. Here, there is no such provision as gift. So, total consideration amount, balancing out. Lordship kindly sees 2.1. Seller hereby offers to sell and the buyer hereby agrees to purchase. No question of gift. The pledge, purchase the sale shares, including the pledge shares after release from pledge. Buyer shall require and the seller shall give to the buyer proof of satisfaction of the pledge of shares. Subsequent to sale of the sale shares, the seller shall cause to deliver the share certificates together with the duly signed share transfer. The name of the buyer. And 3.1, seller agrees to sell and buyer agrees to purchase the sale shares, the prevalent price of rupees 3.7. 3.2. And 3.2 is important. The consideration for the deal is the price as per para 3.1 and release of the personal guarantees of the directors of Prabhu International. For the fund-based and non-fund-based working capital of MBL, not AAP is not covered here, which the seller considers very essential for smooth running of its business. And the validity of the MOU clause 4.1 is 18 months. Release of pledge, release of pledge, release of pledge, release of pledge. And Lordship, rights of the buyer, Lordship kindly sees. Five point 1.2. 5.1.1, right to purchase the shares. 5.1.2 is important. Buyer has the right to sue the seller for specific performance in case the seller does not sell the sale shares, including the pledge shares, after satisfaction of the pledge within the validity period of this MOU as provided. Now, this is the pledge shares which have been sold 1 month back.
So your suit for specific performance was in any way time barred, wasn't it?
We filed in 15.
No, 18 months from the date of this, your cause of action arose from the date of this agreement.
So that is in 2014.
Sometime in 2015, let us say.
15 we filed the suit. So that was
filed the suit in 15. Oh.
April 2015. April 15, and thereafter there was an extension of them. April 15. So their application is filed for specific. The other side's application is in 2023. That is my case. Theirs is time barred because they have not filed any counterclaim in the suit. Not filed written statement also. That was one of my various grounds. But that application is still pending restitution, so I'm not going into much detail here. So these are the two MOUs. My case is that the first MOU can't be superseded by second MOU because the first MOU is firstly at the highest, it may have been modified. So the MOU has not been superseded because the compass of the first MOU is much wider. It covers 55 lakh shares. It covers transfer of Prabhu International. It covers subsidiary companies, associate companies, joint venture companies to be transferred. It covers personal guarantees of ARP, given for ARP's loans. It's much wider. If at all there is any overlap, it will be modification. It cannot be a supersession for sure. There was a modification, whether the modification was at all implemented and given a go-by to or not. Those are matters of consideration. Our case is that this October MOU was a non-starter, especially after our specific performance. তোমার 24 কোটি টাকার পেমেন্ট একটা বার করো আপনার ভলিউম 1 আছে Now Lordship, I give the details of the share transfer. Page 114. মনে থাকে দেখি আমার সব মনে থাকে page 114 is the particulars of the share transfer. This chart is undisputed, figures are undisputed. Yes, their case is that this was pursuant to oral agreements. You kindly seize 114. It's too small a chart. This should have been much bigger. All starts from September 13. Oh, well, Lordship kindly takes a look at 139. This is a much more legible and bigger chart. Yes, 139. You can take it. 139. Hmm? 139. The same chart in a more legible format. 139. Intertransfer taking quickly. Intertransfer, sale oblique intertransfer count. Whatever. Lordship kindly sees from September 16, September 13, there are these share transfers. Prices are also given. Lowest price I find is possibly 63.94. And the highest price is 289.50. Page number good, as per the paper book too.
As per the paper.
Two things important, Lordship. One is the date it commences, and two entries, Lordship. The last one, 6th of June 2014. Out of the 38 lakhs is 19 lakh 8,357 is gift. Zero consideration. And one more gift is the one dated 8th January 2014. There are two gift transfers. So the one more.
165.
Oh, 165. Also, sorry, it's a mistake. 23rd December also is a gift. Though by mistake it is shown as sale, but the consideration is zero, so it will be. So 23rd December 13, 1,65,000 shares. 8th January 2014, 1,65,000 shares. And last date, 6 June 2014, 19,08,357 shares. Altogether, they add up to something like 22 lakhs. কিন্তু কম তো গরম করতে পারি না, আমার গরম করার তো ক্ষমতাই নেই। গরম হতেও পারি না, করতেও পারি। Now, Lordship, here, the other thing of importance, let's take the sales shares. Lordship, take a look at some of the shares transferred to me now, signed by them. Prabhu, or the main company who is now fighting with me, they have transferred certain large blocks of shares. 26. In this chart only there are there. Can you take a look at the paper book, page 59, which they are calling these are pure open market transactions, have nothing to do with the MOU. Or should kindly see page 59. This is signed by Prabhu and submitted, their declaration. Should kindly, in compliance of that SEBI insider trading regulation, can you see page 60 is the attached form. There are two transfers. One is 2,79,000. One is only one transfer.
So you are showing these things to support your argument that the March 2013 agreement, MOU, was given effect to maybe highly belatedly but in fact given effect to by the parties.
Not highly belatedly, I would say from after July 30.
From September 2030.
But it continued thereafter. So that will take me to Article 54 of the Limitation Act. If you come for specific performance, if the time is fixed, but if then it is from that date. But if the time is not fixed, then it's from the refusal. But when time is fixed, also then when it's performed beyond the time, then first part moves to second part.
Within what date you paid the entire 24 crore or whatever you have paid?
24 crore was paid by.
You paid it in tranches, in installments.
Last was it up to June 14.
June 14. And their transfers were?
All contemporaneously. Transfer but for page 139, the transfers was
June 14.
Yes, even the gift also was June 14.
Everything was June 14. After June 14, what happened? Nothing. You filed the suit in June 15.
For the other MOU.
2015.
After June 14, there are few correspondence, and I get the remaining guarantees released till 2021. And they ask us to release the guarantees because our obligation is twofold: guarantees released and shares transfer. That continued till 2021. Their case is that you release for your benefit. You got the benefit. After all, you are the borrower. You are equally liable as a guarantor, and that is the clause. We have to get the guarantee release, and also show their title deeds were returned to them, which were given as security till August 2021. Correspondence and the factum of release, and the refusal. That is for the first time in January 2023. So 2021 is the last guarantee I released. 2022, I invoked the first stage of the amicable settlement or amicable settlement first stage. And thereafter, they say, I will not go to amicable settlement. So that was their refusal to perform. That was in January 2023, and we came to court in April 2023. Now, Lordship, here, this I am showing page 60 to show that these are not really page 60, the fifth column. Inter-promoter transfer through stock exchange. And the other interesting part, so far as this is concerned, the sale has happened here on, as per this. Lordship, the third column is the date of receipt of, or the date of sale really. It's 17th December 2013. And the fifth column is inter-promoter transfer through stock exchange. And the 10.5. It's same 10.5 to 405 আছে 10.5 to 400. Had it not been
Yes.
Had it not been as per the MOU, the sale, Lordship has seen the third column 17 December 2013. But an advance return was filed in 10th of December 2013, that the shares will be transferred at this price. So, stock exchange transfer, a tentative price was mentioned. It will be transferred on 17 December. But that return is page 405, volume 3. Page 405, volume 3. I'm sorry, but this should have been. Actually, this is a matter which required a convenience only, but then everything will become a big part of a convenience.
How many volumes are there?
10.
On the next date, please come back with a convenience volume.
And I'll give one sample return, but then I'll be accused of not giving the others. Please protect me when Mr. Chaudhary.
If possible, the convenience compilation
Should be given to them.
Prepared in consultation, so that my lord,
Yes.
by mistake,
If
he
they want
doesn't
to
leave out what is inconvenient
Correct.
to him and vice versa.
So that he.
Correct.
Hey, Anuj, you know, they were told. So, Lordship, 405 is the form filed on 10th December. Can you see the date of the form? At 407, 10th December 13. This is by the buyer. 10th December 13, he intimates that these 2,95,000 shares, which are the subject matter of the page 5960, the দুটো রিটার্ন আছে নাকি এখানে 279 shares আছে ওটা percentage আছে number of shares কোথায় আছে 20 yes 295,000 shares exact this form is filed on 10th December 13, 7 days before the transfer, and where it is mentioned name of the acquirer, row 2, MBLA, and 4A, name of the person whom shares are to be acquired. Prabhu. If it's a stock exchange transfer, as Mr. Chaudhary was trying to show, I will never know who I'm selling what shares on 7 days earlier. And Lordship F, 4F is also, and when it will be sold also mentioned. 4B, proposed date of acquisition 17 December. So the new in advance 17 December.
Shares are also same.
20,000 shares and F. Rationale, if any, for the proposed transfer is interstate transfer of shares between promoters. This is filed by the seller along with page 408, another form, regulation 10.6.
After the sale takes.
This is immediately after the sale takes place, the seller files, and the one at page 5960 is the buyer's form. So 5960 is the seller, and 405 and 408 are the buyer. The buyer gives in advance that I am going to buy these shares. On 10th December, the buyer gives, on 10th December, the buyer files the return, that's page 405, and I am going to acquire 2,95,000 shares from the seller Prabhu at this price as inter-promoter transfer. This is advance notice. And after sale, there are two returns filed. One by the buyer, one by the seller. The buyer's return is 408 and the seller's return is what I had shown earlier, 59. And they all match.
The last document you showed that form dated 10 December. Which page was that?
10 December is 401 is, yes, 405. That is the pre-transfer form.
405.
That
yes.
is by the buyer.
Yes.
And then comes two forms after the sale happens actually. One is by the buyer, that is 408. That's my client, MBLA. Not my client here, but then my group concern, MBLA capital. 408, the sale has actually happened to the named, from the named seller to the named buyer. Numbers tally, the date tally. Oh, my juniors prepare the chart. Acha. This chart may be useful. Endoscopy So, one form filed on 10th December by the buyer, that is page 405. In going by chronologically, the next form is filed by the seller. 19th December 30th, that's Mr. Chaudhary's client, Prabhu, which is page 59.
So 408 is filed by Prabhu.
408 is no by MBLA.
MBLA.
The buyer. Buyer files one before one
So
after.
1012 is seller.
No, 1012 is also
Also buyer.
1012, the MBLA files that I am going to acquire
Right.
from Prabhu on 17 December, 295,000 shares. 17 December, the sale happens. Then both buyer and seller had to file a return. Here, the seller, Mr. Chaudhary's client, Prabhu, files the return on 19 December. This page 59. And the buyer, my client, files one day thereafter, 20th December. Page 408. So, this is for 90% of the share transfer. Around 10%, I mean, for all the share transfer, this is there. But for 10%, the word inter-promoter, interstate transfer between promoters is not there. Out of the 35 lakhs, all of them have that. And I will show one case of gift, where how is it shown by in case of a gift transfer. Lordship takes a look at the, this is the 19 lakhs, 19 lakhs. 19 lakhs in name. Lordship kindly takes a look at the page 454. Symbol in the our volume. This requires a convenience. 454. This is the case of a gift.
এটা রামগোপাল মাহেশ্বরী
একটা gift দেখিয়ে দিন, সবগুলো দেখাবো কিন্তু।
এটা আমাদের
ও আচ্ছা, ঠিক আছে, আমরা বার করে দিই। এটা কবে ট্রান্সফার হয়েছে?
4 June 2014.
But here Lordship knows page 454 is the advance return filed by the buyer. Is Anjani the petitioner, the appellant here. And Lordship kindly comes to page 455, number 2. Name of the acquirer is Anjani, number 2, and Lordship kindly comes to 4A. Name of the person whom the share is transferred, Ram Gopal. Proposed date of acquisition is 4th June 2014. And E is important. Price at which the shares to, here in case it is nil. Shares to be transferred off market as gift by executing a gift deed. And the category is the same, F. 4F, interpromoter transfer of shares. 4F. This is given by, this is going to be transferred on 4th of June, and this form is filed by us, by the buyer on 28th of May. Now, after this 19 lakh shares are actually transferred on 4th of June.
That is page 39 of the paper, volume 1.
Ram Gopal. But you kindly now have to go back to volume 1. Page 39, they went to page 39.
Page
39, paper book. This is the Chaudhary's client's form. I mean, their father, my elder brother Ram Gopal Maheshwari. This is given after the transfer. This is signed, it's dated 6th June, page 39. the covering letter, we couldn't find it.
It is written that 4th June it was transferred.
Is signed. Yes.
Date of
Third column, I mean, the second column, the number of shares match. Third column is 4th June transfer, as it is said in our advance return.
mode of acquisition, inter-promoter transfer.
Mode of acquisition, inter-promoter transfer, and the consideration is nil. Through gift. Where gift is bola hai gift? Inter-promoter transfer through gift. Yes, through gift.
Where are you getting it?
The third, fourth, fifth column. Very small. Fifth column at page 39.
39.
Inter-promoter transfer through gift. The last column is sale value. That's not applicable. NA.
Sale quantity is the same as
Sale quantity 19 lakhs. No, I'm just showing one of each. The other gifts, there are other sales. Whether this is oral agreement, each one separate oral agreement, 30 oral agreements. Or whether it's the MOU, that's the trial issue. Especially when the MOU contemplates gift. And it's little absurd to say that 30 oral agreements and 30, I mean, these are not open market sales outright. These are all pre-planned sales.
There's no with respect to them denying the share transfer by gift. They are not denying.
No, there's no denial of the share transfer by gift. There is no denial of the money received. But as he's saying, he's denying because he's saying it's open market. Now, Lordship, though in my humble submission, Article 54, once it moves on to the second part, the limitation will start running when refusal happens. First part, if it's a date fixed, it's on that date limitation starts running. If it is that date fix is given a go by, then it comes to refusal. But Lordship, what do you know what has happened in between 2014 to 23? Lordship kindly comes to the share transfer. Guarantee release take dekho. No, I guess 17 देखिए their main paper book এর volume কত জানো? Volume 116. Their main trump card 116. Page 116, volume 1. The first of the written interactions after the last guarantee was released in the last of the guarantees before the 2021 is in December. Well, June was the last payment, and then the guarantees are released till December 14, but for one which I'm coming later, December 14. Then there's a lull for 15-16 because the company goes to CIRP actually. Now, 116 is their letter, 15 September 17. That is Maruti, who is one number one, who's the director of Prabhu. The third paragraph. You are well aware that I had resigned from the board of ARP Infrastructure in August 12 as a part of settlement of dispute between us. Now, whether there's another oral settlement, how many oral agreements, and not the MOU, that's again arbitrary. Very unlikely. You were supposed to get my personal guarantees released from the bankers of ARP infrastructure. That's only unique to March 2013 MOU. Under Secretary, you are requested to urgently sort out the matter with the bank at the earliest and keep me indemnified. You are also requested to share the correspondence. They choose this time because this is in September 17. কবে CRP তে গেছে? March 2017, MBL goes into CRP, our darkest period when things go southwards for MBL. And as I've never said, MBL I'm not the controller. That was my darkest phase when the company goes into it. But then I only revive, I only get this out of CIR. So this is in March 17, it goes into CIR, 30th March. And in September, they write this letter, referring to a settlement. And we, of course, write back, kindly see page 117. No, not 117. I want to reply to 282 is our reply. Sorry. Page 282 is the reply. Next convenience volume না করলে মানে I deny. I am surprised to receive your letter number dated 15 September. At the outset, I deny and dispute the content. It is denied that there exists any settlement of disputes or agreement by which I am responsible for getting your personal guarantee release or to get you. I deny it. Page 282.
So you're denying this.
I'm denying. So as I'm saying, there was a denial from my side. But thereafter, I follow it up. I do it. So as I'm saying, this is, I'm denying it. But thereafter, I perform it. To what extent that will weigh against me, whether but দেখো তুমি 2018 তে 2021 issue. Now going back to page 118 volume. Explanation টা my explanation for this in my affidavit, whatever it's worth, is that we had written this because at that time they had refused to perform the MOU. Or you will see till this date, till September, till 2017, there's no refusal. They keep transferring shares, I keep transferring money, I release the guarantees, it goes on. Page 118.
Orally confirm their commitment, we have caused the responsible guarantees to be released.
Hearing held, applicant bank submit matter is settled. This is up. What you see, BOB versus up. In view of the statement made by both the parties, the present OA is disposed of as settled as withdrawn. Registry is directed to return the court fee as per rules and return the original title deed documents. And
It is returned on 4th August.
document
Volume 2 fails.
You paid the dues of Bank of Baroda.
yes,
There's evidence of that.
the settlement.
No, settlement doesn't say that you paid off their dues.
So I settled their dues.
And it is released. The title deeds were released.
And
You
title
were a
deeds,
party to this DRT proceeding.
Yes, yes.
up is my company.
Up is your company.
Up is my, is the subsidiary of MBL. That is why for ARP's liability, they had given, Prabhu had given a guarantee which had to be released. And now the next volume, volume 2 take it. Now, page 178. Yes, yes. Now this is very clear. Page 178, volume 2.
This amount was voted by
Hmm?
OTS amount paid by.
This is the letter received by UP.
Issued by bank to us.
This is a letter written, marked to us, but to Maruti Maheshwari, the guarantor, that is Mr. Chaudhury's client, guarantor to UP. And I got it released, that is said in first paragraph. I paid the money. The borrower is UP. With reference to above, actually, we like to place on record that the said account was transferred from our branch to Delhi. Subsequently, the borrower had approached New Delhi for one-time settlement on 26th of August 2020 by the letter so and so. In response to above OTS proposal, the competent authority of our bank has sanctioned the OTS for 8.50 crores on 22nd September. Pursuant to above third paragraph, we hereby release the original title documents along with all ancillary documents, maps of the below mentioned mortgage properties to you in the capacity of mortgager. Unlike in their case, where they get the pledge shares sold and the price adjusted, we do not get the property sold and the price adjusted under the surface. That way also I could have settled with the bank. We get their property, we get the property released and returned to them. It is only after this, when I discharge my obligations, that I the only thing which comes against me, as your lordship has also expressed, that in 17 I denied the agreement and I refused to perform. Now, before Justice Shortcut, this issue also was argued. This could be a factor whereby in a specific performance case, this is the arbitrator, my refusal to perform could be a factor against me. But after I have performed it, whether how far that it will weigh against me is also a questionable thing. And secondly, just by, say, the petition section 11 or section 8 or section 9, there's a written arbitration agreement. At one stage, the petitioner had denied the agreement. Will that preclude the petitioner from filing from going to arbitration? Or does the arbitration agreement disappear with one letter from either of the parties that there's no agreement? The agreement can't disappear with one letter. In fact, there are judgments also which says there are disputes. Unless there are disputes, one doesn't come to court and or go to arbitration. During dispute, one refuses, one agrees, that points change. But the agreement can't be wished away with a letter that the agreement doesn't exist. So that 17 letter will weigh against me in specific performance that at one point I had refused. I had denied, I had refused. I denied my obligations, I had refused. But then I have performed it. So if it ended there, then it would have come against me. But then I performed it. And It is only thereafter, Lordship, also very importantly, I am the fraud here. I have paid 24.95, got all the guarantees released, and they have asked for specific performance of an agreement of October 13 for the first time after they get everything done. All the title deeds, everything goes back. They write in September 22 for the first time. They write saying that you now perform the that October 15 MOU.
As of date, all the personal guarantees stand released. All mortgage properties stand released.
Returned to them. From my side, 3.5 crores to be paid. From their side, shares transferred, and the Prabhu's shares have not been transferred to me at all. Prabhu is supposed to be my company, and he's fighting away against me. As per the MOU, Prabhu is supposed to come to me.
So today you want those shares at,
And the Prabhu
at
to be
63 rupees, no?
No, out of that 28.50 crores total consideration.
Oh, I see the remain balance amount, which will be about 3.5 crores.
But now it has to be adjusted because I won't get all the shares. They have sold off some of the shares. Then these 5 lakh pledged shares have been sold off.
Whichever shares they hold now, what will be the worth of it going by the present market rate?
If you add the bonus shares also, if it is ignored that the bonus comes also with it, more than 8 crores. May not be, I don't know, I have to.
Are you willing to pay that kind of money?
No, certainly not. So I got the guarantee release free of cost. I got guarantees worth 300, 400 crores released. I got all their title deeds returned to them. 28.5 crores is a lump sum consideration for all.
After all, it's your company.
My company, MBL. And the MOU, it's a composite transaction. I give 28.50 crores, and they get like there's a lot of transaction in kind.
So really, the question we'll have to consider is whether that MOU of March survives.
That is the issue.
That is the issue.
Whether it survives. If it doesn't survive, then if it's a clear case of novation, though of course nowadays even the recent judgment says novation is no longer that Kishorilal principle which we follow, just Bachawat's and judgment here and the Supreme Court, that novation, the agreement is gone, so there'll be no reference to arbitration. That's been substantially diluted of late Sanjeev Prakash and later, that this now everything goes to the arbitrator. With the amendment of section 11, so everything goes to the arbitrator. But as Justice Kapoor has also noted, so that Lordship, of course, prima facie finding Lordship has to give for the purpose of section 9. There I'll have to show that that October MOU could not have killed the March MOU. Really,
keeping aside the question of killing or superseding.
Superseding, same thing, is modifying it.
Or you are saying at the highest modification. What about a complete go-by?
Complete go-by. Complete go-by, if it was given a...
They will surely raise this.
Yes, they are. No. Their case is that this was superseded, as you've seen, but then if a complete go-by by a subsequent agreement. Legal parlance, go-by is really 60 to waiver. And I waive the obligation to perform.
The party is not acting on it within the time prescribed or otherwise within a reasonable time period.
Then October 13 MOU also goes, because October 13 MOU has not been performed at all. They are seeking specific performance of that in the next court.
Tomorrow they might withdraw, we don't know.
They may withdraw.
Specific performance.
That's for restitution.
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 No, now their application is for you.
Yes, that is because they see you have caused, by enjoying that order of injunction, you have caused loss to them.
No, but their application I will show, which they filed in 13 March, which is the genesis, that you performed the agreement. That is then the suit wasn't withdrawn. Theirs was you performed the agreement. October 13. After that only the suit was withdrawn.
I am writing to them since 2017. My learned friend is not correct when he says that.
2017? আর কি চিঠি আছে?
First April 2017, they write to us, and that is
Yes.
only after the company was admitted to CIR.
That after admission to CIRP, there is a letter written by them.
First
No,
April
आप guarantee আর তাছাড়া কি আর কি চিঠি
There are
আছে?
6 letters, at least 6
On
letters.
1st April 2017.
70 এই তো এখানে
No, I can.
তো but be that as it may, October 13 MOU has not been performed at all. There, the pledged shares were never released. And the first time they came to court, letters apart, limitation, legally they asserted was in March 2023. The time expired in 16, after the 1-year extension. Now the March 13 MOU, whether it has been given a total go-by to, that is their case. Let's put it, bringing it down from supersession, that both parties agreed that we are discharged of our obligations. For that, I would say this becomes a very triable issue because of the share transfers. With the prior notice to the SEBI that I am going to buy these shares. Prior notice and corresponding, they are giving the returns. The shares transferred by gift. Then it all becomes as per oral agreements. Now, whether this was really as per oral agreement or this was, the MOU was given a go-by to. I get all the personal guarantees release, title deeds release, all out of goodness. It can be out of goodness, out of brotherly love, or out of some separate oral settlement. But this becomes a triable issue. I am not saying today ultimately I'll succeed, but it becomes a triable issue because whether all this was performed, because one has a right, July 13, one has a right to give a go-by to the date. Section 55, if it's a time-bound contract, parties by going beyond it gives a go-by to the date. Thereafter, it ceases to be terminable on the event and it becomes terminable by giving notice. So it was, according to my case, this was performed, and all these forms don't say as per MOU did it. So, but there's no provision for as, but there is a prior agreement. So this was performed, and after July 13, it was given a go-by. The arbitrator may hold that this was given a total go-by to it out of goodness or out of other settlement. The shares were being transferred by gifts. The shares were returns were being filed, prearranged. Guarantees were being released.
55 lakh shares for 28 crore, let us say. How much it comes to per share?
51 rupees per share. Now, here, now when it comes to, now Lordship kindly sees how, whether they can resurrect this case or not. Lordship kindly comes to, my juniors, they are always more alert than us, than me, not us, sorry, than me, because kindly comes to August order দাও তো, August order page 320 তে বার করো তো, 320 ভলিউম তো ছড়ানো হলে বড় মুশকিল হয়।
Page?
I think it's 320. Give me 1 second. Yes, 320. They are saying 63 rupees MOU they want to perform. Share price was ranging MBL 153 rupees at that time. And I was with a begging bowl asking them to perform the October MOU. Kindly see page 320. The first order is passed at 318 and then 320 when this matter is taken up for hearing. This is to the reservations of the October 13 MOU. Second paragraph. The defendant seeks to raise several grounds, including that the suit is not maintainable. Relevant agreement is unstamped. Transaction pertaining to 17 lakh shares is hit by the specific, by the Security Economy Regulation Act. And the plaintiffs have failed to honor the plaintiff's part of the bargain. On the previous interlocutory application,
Here the letters, 1st April 2017, they say that you perform that about October.
Price.
at that time, the share price was FBL was 153 rupees. Or more than that. When I filed the suit in March 15, the share price was ranging around 400 rupees. They were not willing to transfer. They were saying the contract is void. Securities Contract Regulation. They allowed their claim for specific performance, right to specific performance, to be greatly time barred. They don't get the pledge released. They do not file a suit for specific performance saying that you get my personal guarantee released, you get you give me the money and I will transfer the shares. Because the share price is more. And I've got the official quotations. April 17
But 8th March, MBL admitted to say.
Now, Lordship.
Now they say that you can't perform the MOU. 1st April 2017. 2 letters in 2017, then they write to us in 2022.
Section 14 देखो तो specifically तुम्हारी IBC देखो तो मुझे क्या share transfer करा जाए क्या देखो तो Mr. Chaudhary said that there are 6 letters. He's right. On 30th March 2017, the MBL goes into CIRP. Page 367, the same volume, it is there, 367. The barrage of letters start. 367, 1st April 27. 2 days thereafter, 1 day thereafter, the first letter. That's also to time barred by then. October 13 MOU, first. I had to check whether a company who's in CIRP, whose shares can be transferred by a private transaction, section 14 of the IBC.
Company willing to know the company. His assets are. As it is.
Company asset. मुझे share company asset है.
अच्छा है ना.
And this is a fraudulent transfer. Lordship.
CIRP you went end of March.
30th March. 30th March.
13.
2017.
17.
At 1st April comes the first letter. If I had transferred this lordship, our old 536 of the Companies Act, if the after post company going into winding up is admitted, if there's any transfer becomes void.
What is section 14 of the IBC?
Section moratorium wouldn't apply because these are a company's own asset. Company's shares are the company's assets.
Correct.
But what will be coming is section 43, 45 for the what do you call, prevention of undervalued, the preferential transactions. It will be coming undervalued transaction, preferential transactions, companies' shares are being transferred. And also, as face facts, I didn't have the money to purchase that. They filed a suit at that. Because they can't, because at that time they know that I can't be enforced. So they write the first letter you transfer is 1 day or 2 days after the company goes to CIP and the price stops. Up to 17, up to 16 is the last order. Price is high. They fight tooth and nail in court. So please don't try to balance equities here. I would say equities, both sides there are lapses. I mean, both have not acted very fairly, like I can say. I personally feel my client has parted with the money, got the guarantees released, first title deeds there, and they're just sitting on the shares. Whenever getting the opportunity, they're selling the shares whenever they can, directly, indirectly. But be that as it may, they also have a grievance that in when April 17 onwards till 21 till 2021 we were not responsive. But be that as it may, that is a right which has gone. Their right to specifically perform the agreement is gone, and indirectly by restitution, if you want to get that.
No, we are not concerned with that.
That is a different matter. So that's only on equity. After all, Section 9 is the equitable jurisdiction as well.
Yes, and injuncting relief is.
Injunctive relief. So
that's all.
No. So he's right. I missed out because this is not from April 17. There are two letters. There are two letters. 1st April, then 14th April. Then one more 10th of May. 3.
And then they write in 2022.
Then 2022. After I get their personal guarantee release and title is returned. Now, then comes, I could have come to court with a specific performance case after having denied the agreement in 2017, which I had shown when I performed it actually in 2021 August. That part of the obligation of getting the guarantee release, I could have come after 2021, come to court and said, I have discharged my obligations. Now you discharge yours. Subject to, of course, what is the effect of the October 13 MOU, its modification or a go by. That legal aspect apart, I could have come and said, you perform, other than I'm now enforcing my right under the MOU. I came for the first time in 20. I came 1 year after that. After I performed in August 21, actually in December 21, 1 year and 3-4 months.
And you revived when? MBL revived? Came out of CIP?
Came out of CIP, it was 18 only. We came out on 18.
2018, our resolution was upheld by the Supreme Court, 31st January 2018.
18th April 2018, the resolution plan was submitted and approved by the NCLT Calcutta, but it did not end there because it was challenged by some of the speakers. It ultimately, Supreme Court upheld it in
31st January 2022.
31st January 2022. So that I would say is the final date when we come out of. Though legally it's in April 18, but then this was under challenge before Appellate Tribunal, Supreme Court. Clean chit in April 2022.
Arbitration clause to that because it's two-tier arbitration. First negotiation, then arbitration. Adjournment, that is the invocation. There's a two-tier.
Both are first volume.
Yes.
Oh, my specific performance, my invocation of the arbitration agreement is in volume 1. His Lordship had seen this is a two-tier MOU. That is first attempt at settlement that now page 37 that I was shared out to me. You come straight away to page 136. December 2022, 26 December 20. Where paragraph 3, we have written that got the guarantee released, last of the guarantees released, and the title deeds returned. Paragraph 4, previously you were not willing to accept the balance amount of payment in terms of the MOU, transfer the remaining shares to be and fulfill other obligations and the MOU inasmuch as the personal guarantee of your director, Maruti Maheshwari, had not been released in respect of the term loan of 50 crores by Bank of Baroda, a wholly owned subsidiary of MBL. Now the personal guarantee of Maruti Maheshwari having been released, none of you can have any objection to transferring the remaining 17 lakh 4,000.
So this was your effort of trying to settle the matter amicably as contemplated by the arbitration clause.
They wrote back, this is the first refusal in writing, that is page 140.
Letter issued by Anuj and Maruti, and then the letter thereafter by Prabhu.
This is, like you kindly see, the Anjani, this is written by Maruti and Anuj, is 1 and 2. Can you see the first page 140? Last 3 lines. And even now they are maintaining. Prabhu is not a party. That's because there's no rubber stamp. And Justice Kapoor was convinced with that. Admittedly not a party. So, and today, after all these judgments, even that this issue can't be gone into at all. Because prima facie it's a party, and even if it was not named a party, Niranjan Lal Todi, our High Court, Justice Shonji Banerjee, the 11 said when family members sign, the companies under their control automatically get bound. And now Cox and Kings, Ajay Madhusudan, Supreme Court has said anyone affected can be made, but it's entirely in the arbitrator's domain. You refer everybody.
Please show us those judgments. You have to.
Paragraph 2, last 4 lines is pertinent to state that certain entities appearing as parties to the purported MOU did not sign the said MOU. His company, where it is said that it is Group 1 controls fifth entity. The sign where it is mentioned the parties of Group 1. And paragraph 5, with reference to paragraph 8, it denied that there is any avenue for settlement of any dispute alleged by you against us. It is reiterated that invocation of the purported dispute resolution clause of the aforesaid MOU as against the undersigned is bad. Yes. So this is when
then Prabhu issues a letter.
Or then Prabhu issues a letter, page 142.
This is shares held by undersigned in MBL have been sold. Last sentence of that page.
In any event, the shares held by undersigned in MBL have long been, yes, they have been transferred to me, I think.
Me.
To me.
Or to you.
To me. In terms of the MOU, I still need to make them parties because they're holding on to Prabhu's shares. And Prabhu has to be transferred to me also. Now, they are calling this open market transfer and independent. Now, Prabhu writes back, kindly sees page 142. Is the same person writing?
No, this is written by Aditya.
Oh, the other brother. At the outset, we deny allegation, deny that the company executed the purported MOU The company is not bound by obliged terms to comply with any term appearing in the purported MOU. It is denied that the company had acquiesced in the release of any personal guarantee. And basically, they deny.
Sorry, but also there's admittedly after the company has gone to CIRP, they say by letters dated, we have called upon you to perform that MOU. That is their letter. Next, please. Paraphrase.
Oh, on the one hand, they say they are parties to the MOU.
This is for the other MOU, subsequent to the aforesaid orders on several locations, including
Other MOU.
including the community. This is only after the CIRP. This is
বললাম তো April HD দিয়েছে March even CIRP they repeated that in the on 1st April they write what they performed the October 13 MOU. Now Lordship comes to the section. Now they file an application which is so we file
now they file G3 on 1st March.
on 1st March 2023 page কত পেজ আছে
333 volume 3
volume 3 333. This is the application they file. Pure specific performance claim. Not judgment upon admission, not without a written statement, leave aside counterclaim. Page 48 are the page 334 are the prayers. Order directing transfer of 12 lakhs. That was not the entire MOU. Because 5 lakhs they're supposed to de-pledge, and if they want to perform the MOU, they can't ask for part performance.
This is the file on
1st March 2023. In terms of for performance of October 30.
Propu files.
In the suit. And this is the valuable right I take away by withdrawing my suit. They would have got this order in their.
They have not de-pledged. That MOU also they were to require to de-pledge their share.
And this.
First March, 31st March.
First March.
First March.
So this is the application, and after we withdrew the suit on I think 28th. 3-4 weeks after this application. 1st March, 4 weeks after this application. Page 386 is the order. I kept the suit pending. This is a, I suppose, strategic mistake from our side. This application would never have been allowed without a counterclaim being there. This is, the defendant, but we withdrew the suit 386. Client didn't want to spend money on litigation. 386. And so then we filed the section 9 application thereafter on 19th of April 23. We're on the first day, or volume 5, 595. I think it is recorded. I don't think my prayer is recorded. It's 590. Page 594.
When did you file?
10th April.
10th April. 23. I don't see the nexus between my withdrawing the suit has a nexus with their application, no doubt. My client didn't want to fight the suit anymore. But this, what is the nexus, I do not know, because I had invoked it in December itself. this arbitration clause. Because I did not even pray for interim order. Affidavit directions given. June tak hota hai.
6 June 595.
Now the whole second round of drama begins with 595. 6 June return the correct. 595 on 6th of June, the matter is returnable, and we also did not really oppose. Actually, first extension, no one really opposes. Extension of time, 595, opposition time is extended by 2 weeks on their prayer. 595. Next, on the same day, can you see, we filed, this is uploaded a day or two later, page 596. Same day they filed the return. Transferring
Seventeen nine four one 80,000 and 7040. Page 597.
Page 597, কত দাঁড়াচ্ছে সে পড়া যায় না.
17.
Not legible.
But they upload this share transfer. They apparently had effected, they upload on 6th of June. They effect the transfer.
It was 31st March 2023, 2nd June 2023, 5th June 2023.
The three transfers, 31st March 23, 2nd June 23, and 5th June 23.
Where do you get the date?
The third, fourth last column, date of allotment, advised acquisition. The column 11 and 12, column there, faintly the numbers feature.
Total 1,04,981.
1,04,000 shares, and then again,
Please ask your advocate on record to get better copy.
in the convenience volume which I want to include, I will include issue. 598 is on 9th June they upload another return. Where kindly come to page 599, columns 11 and 12. Further transfers on 6th June and 7th June. Kota 1 lakh shares. Another some quantum of shares.
So Prabhu sells shares in NBL.
After invocation of arbitration and during pendency of the section 9 application.
Order 19th October.
632. Upon seeing these returns which were uploaded, we file an application that this is happening. Ashok kindly comes to volume 5. Volume 5, that is there with your Lordship. Page 632. Say order. 20th June.
630.
632. The fourth paragraph. Since the date for the section 9 633 for date of section 9 proceeding has already been fixed after affidavit, parties are expected to and shall maintain the state of affairs as was existing on 6 June 2023 until the Section 9 petition is decided and disposed of. So this was the order that was subsisting. They did not restore back 6 June because after 6 June also they have transferred shares, quite a bit of shares. 6th, 7th June they had transferred shares as per the returns. But this was the order subsisting. And this is the order that is then vacated in
by the impugned order.
March or February this year. Now comes I'm just finishing the facts since I'm GA2 now. GA2 bar করো GA2 GA2 লাগানো আছে GA2 তো দাও GA2 ওই তো GA2 Kelly takes a look at GA2. Page 74 of GA2 volume.
Page 74
of GA2.
Yes.
This is my third round of problem, or the third round of dispute. Page 74. Paragraph 4 of the order is the paragraph 4, page 75 is the relevant, is the order subsisting. In view of the fact that there appears to be a part performance of MOU dated 17th March 2013, we consider the prayer for interim order subject to the appellant securing a sum of 8 crores by way of bank guarantee or any other mode of security. That is acceptable. Now, this no restriction, and to today there are, I think, less than 3% shareholder of the company. Suddenly, their concern for the company seems to be heavy, going overflowing concern for MBA.
306.
You furnish this bank guarantee.
Yes, that is 1 day's extension. Space 7 I furnish the bank guarantee to satisfaction, and as your lordship knows, registrar conducts proceeding upon notice to both sides. The guarantee is furnished. I don't know. Now, lordship, this guarantee is now comes from May 2025. This order is in March, 3rd March. Page 306, volume 3.
Page 306, volume 3.
Of GA2. Of GA2.
Wow, GA2, volume 3.
There are 3 letters, May 6, May 14, May 16. May master. That's May 21st, the mail system. That 27th into a letter, 28th May.
306, they write to all the directors and CC to the bank. It seems that the above bank second paragraph is guaranteed to be submitted to the registrar original site as per Honorable Court's order dated so and so. You are well aware that this case is between Anjay Lakhotia, promoter shareholder of MBL, and the chairman of MBL, Maruti Maheshwari. MBL Infrastructure is a listed company and has got no relationship with the case of APOT, other than it is a case between two sets of shareholders promoter. Please note that this issue of BG against the banking limits of MBL The serious violation under so many parameters of IBC code, company law, banking law, SEBI. What do you put?
21st to
Really follow.
21st to 26.
And this is followed by reminders, page 322, first reminder.
I reply at 3:26.
They are not interested in securing the equity. They are now, once they've got the security, then they now want to.
Shall we stop here today? You look exhausted.
I was hoping 3:30 to say there will be something fixed.
When? Please keep as much continuity as possible.
Well, the only thing is the convenience volume, so that
Oh, it'll take.
can keep it next week because I want them to both sit and do it. So kindly keep it as far as possible. Or if they give some continuity, it will be good. From if you can give Monday, Tuesday, 2 days if possible.
Tuesday, normally the appellate side list gets exhausted. We don't have a long. Get it now. He's not there next Monday.
No, Mr. Chaudhary.
Chaudhary Malad is traveling Malad from 19th to 21st, 31st Malad. That's a difficulty Malad, but Malad.
You are here, Mr. Singh. Because please understand, we'll completely forget.
I understand. Very well.
So today is what? Kau tarikh?
Doesn't matter. আমার ওর এবার তো থাকবে না।
21st?
Second half করো। Thursday second half if it's possible.
Which Thursday? 24th?
Yes, by the time 17th Thursday if it's possible, then
Yes, 17 this week. Yes.
Then we get the compilation should not take that much time.
17th, this bench will not be there.
Friday, Lordship, second half, Lordship has got other matters fixed. First half, Lordship next week, next Monday.
Monday.
Or Tuesday, Lordship to take them up on Monday.
Monday, if it doesn't conclude, it will not conclude. Tuesday after appellate side. In fact, Tuesday he'll be there.
He'll not be there from 19th till 31st Malad. He is traveling Malad. Abroad.
What to do, Mr.
I'll be there. No,
He'll be there.
Only that we need some time to compile the documents.
By Monday, হলে অসুবিধা কি? তোমার 7 দিনে বেশি লাগে।
In that event, we'll fix a time also.
Yes, 2 p.m. is very good. Then we.
No, not 2. Not 2. Either immediate. We will fix it at 3:30. It's a Tuesday.
And Monday, what you say?
Monday, no time is fixed. It will be at the top of the.
So then Tuesday, make it 3 p.m. then, because then we can meaningfully do something.
On Tuesday, very well, 3 p.m. ওটা তুমি লিখেই রাখো 3 p.m. ঠিক আছে? Mr. Mitro, learned senior counsel representing the appellant, begins his opening submission but does not conclude. Paragraph as requested, list this matter once again on সামনে সোমবার দিয়ে দাও at the বাবু শোনো ঠিক করে Monday date দিয়ে দাও at the top of the hearing list or whatever list it is. দেখে নিও কি এতে আছে. Stop. It is understood that if hearing of the matter is not concluded on such and such date, Monday date, the matter will be again heard on every Tuesday date at 3 p.m.
I allow my juniors to remain virtually so that they can.
So long as the arguing counsel is there.
I am there.
The affidavit in
The affidavits may be.
Affidavits we shall give it next day.
Sure.